The following podcast contains opinion and commentary protected under the First Amendment and fair use, as well as public records and freedom of information laws. The content may include adult themes, adult concepts, and adult language not suitable for all audiences. For the safety of all, no viewer should ever engage with, interact with, seek out, or contact in any way persons being discussed, including those under criminal prosecution, and especially those that state,
"It's not like I've gone and killed somebody!"
Viewer discretion is advised.
David could offer some clarification because he helped me answer that question. David?
In the end of the video, you were talking about, Laura, I hope that you never pay Clayton. You could file a bankruptcy. Either way, there's no legal requirement for you to post bond if you don't have the money to be collected. Didn't Laura admit to having $200,000? Where did that money go? What do you mean she doesn't have any money? You don't want her to pay? You're telling your client, hey, ignore this payment of $150,000.
Maybe David could offer some clarification because he helped me answer that question. David?
Laura does not have any money, okay?
I haven't ever in my life had like a 1099 or W-2 job, really been supported by my family.
Her income has basically been destroyed, and she blames JFC for this. She says that JFC has, harassed her podcast advertisers to the point that they won't work with her anymore, and her income is basically zero now. And she never said that she made $200,000. What she said was that was what the podcast made, and she split that with her mom.
Testified on March 1st, 2024, that the horse business, Quartet, made $144,000 of income, and that was split between you and your mom. Do you recall testifying to that?
So the $200,000 that she said at the trial, she no longer has for whatever reason.
She was saying that was her income from the podcast that she was doing with her mom.
But you didn't report that on your bankruptcy, your sworn bankruptcy statement.
Her income is zero, basically zero. Her assets, they are what they are. Clayton is entitled to go and look for that. He can collect his judgment all he wants.
Maybe David could offer some clarification because he helped me answer that question. David?
I said to her a while ago, just if you file bankruptcy, you don't have to deal with this anymore. You just push that red button on your desk that says, boop, I'm done, bankruptcy. The entire case goes away. Clayton's ability to do anything to her in court anymore stops the minute she files bankruptcy. And she won't do it. And she said, I'm not going to do that, as much as it would bring her relief.
Maybe David could offer some clarification because he helped me answer that question. David?
But don't say that I'm encouraging her to ignore an order. She's not sitting on $10 million in cash, and I'm just saying to her, go hide that. She doesn't have the money.
Maybe David could offer some clarification because he helped me answer that question. David?
Don't say that I'm encouraging her to ignore an order. I said to her a while ago, just if you file bankruptcy, you don't have to deal with this anymore. You just push that red button on your desk that says, boop, I'm done, bankruptcy. The entire case goes away. Don't say that I'm encouraging her to ignore an order. If you file bankruptcy, you don't have to deal with this anymore. And she said, I'm not going to do that, as much as it would bring her relief.
But you didn't report that on your bankruptcy, your sworn bankruptcy statement.
And she said, I'm not going to do that. And she said, I'm not going to do that. And she said, I'm not going to do that.
David was my attorney. David signed the pleading.
The fact of the matter is you authorized him to sign attesting that this was truthful, but it turns out it's not.
She has become a friend. I talk to her often. I have spent a lot of time with her, way more. You guys have no knowledge that I do as far as contacting with her personally.
Maybe David could offer some clarification because he helped me answer that question. David?
I talk to her often. I have spent a lot of time with her.
David was my attorney. David signed the pleading.
I have spent a lot of time with her.
The fact of the matter is you authorized him to sign attesting that this was truthful, but it turns out it's not.
Maybe David could offer some clarification because he helped me answer that question. David? 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 David?
Yeah, 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 yeah. Started.
Testing. Testing. 1, 2, 3. Are we here? Are we here? Oh my God. Oh my God. Chat, tell me if we're here. Professional, 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 professional. Are we back? Are we back? Let's see if this works. Holy hell. I should sue StreamYard. Oh my God. See, folks, it does not just happen to Megan Fox. It happens to everybody. And no, it was not because I was muted. It is a StreamYard problem. I hopped into the studio, it worked, and the second I put myself on the screen, all of a sudden there's nothing. No green lights, no nothing to tell me that there's audio going out. So I will 100 and like Laura Owens and her sonograms. 100 million % StreamYard's fault. So, all right. Now that we've had our Friday catastrophe, hi everybody. Let's try that all again. I feel like I should just hit the rewind button. Let's start from the beginning. No, I won't do that to you. Oh, but anyhow, happy TGIF everybody. Happy TGIF chat. Happy Friday and weekend to you replay crew. It will probably be Saturday for those of you who play it on the next day. Good to see you all. It is Friday. It is thank God, the end of the week. There's been but more drama in my, shall we say, private work life, but I won't talk about it right now. I've had enough excitement for the last, 9 minutes? Oh my God. And I wasn't sure quite what happened when I left the studio. I'm like, will it just end the stream or is it going to hang out there in midair? I have no idea. Well, let's find out. Oh, good God. We don't need technical issues here. And even when you try and get everything checked off and the box is ticked, sometimes it will just, as they say in the technical field, shit the bed. And that's just the way it is. But anyhow, yes, we've got so much. Jeep Daddy is not here yet. Yeah, he is spying on us. I can tell you as a matter of fact, because he sent me a text like at 6 minutes in and said, there's no audio. So I know Jeep Daddy is listening. He'll be along shortly once he gets his affairs in order, or at least enough to join us. I've got some good stuff for him that I'm going to save to the end. It just landed, but like 30 minutes ago on the Twitters. The Twitters are always good to us. And it's more stuff about guess who?
The fucking douche canoe.
Yeah, Dingus the douche canoe. And it's stuff that's, I would characterize as being at least borderline homophobic. So yeah, David Gingras is he's just on a downward spiral, and that windmilling airplane headed straight to Earth seems to be picking up speed. But he's not doing it alone anymore. Yes, Marc Randazza has entered the chat for David Gingras's disciplinary proceedings. And what I have skimmed since this morning when I saw them, dare I say, there are a lot of the same arguments David was using. So now I'm wondering, well, did Mr. Randazza do this? Did he farm it out to somebody else? Did he just take David's stuff and fluff it up a little bit to say, well, David should be able to say anything because it's free speech? It's a lot of the same arguments. There's a lot of relitigating Owens v. Eckerd yet again. And I'm going, why is someone of Randazza's, what's the word, acclaim? Fame and acclaim. Why is he hitching his wagon to this? Is he unaware of kind of the batting average going on with David Gingras in this case? I don't know. We don't need to necessarily figure out Mr. Randazza's motives for helping David. And maybe David's paying him. Maybe it's, hey buddy, can you help me out with this? I desperately need a real free speech attorney. Yeah, well, Marc Randazza's got quite a prolific career based on my observations. And as I've said before, I think it was even in our previous live stream, It was sort of an interesting moment when I realized that Marc Randazza had married the principal and founder of a firm I was, sort of initially working with for some of my detractor issues. But they declined to take up my case because it wasn't quite what they like to do, and actually going after platforms more than individuals. So I was not a good fit for Kerry Goldberg's legal proceeding. But that's the way it goes. Meh. It is a small world, though. Sometimes it's funny. It really is. Let's see who else is here. I saw Danny's here. Ms. Wings is here. Big Bad Marcus is desperate to marry me. I don't know why. Yeah. But as I told Marcus at the beginning of chat, if you like it, then you better put a ring on it, or at least take me on a first date. But he lives on a different side of the country, I think. And wouldn't it be funny though, folks? Wouldn't it be funny, out of all this Laura Owens catastrophe and David Gingras catastrophe, that people find true love through this case? And we know that there have been real babies, for people like Greg Gillespie and Mike Maricini. There are real babies involved that have sort of come out of all of this chaos and disaster. But you know what? Why not? Why can't everybody find true love thanks to Laura Owens? So it's just kind of funny to me. Oh, there's all kinds of people here. Deb Peterson's here. Wallace, good evening, everybody. Oh my goodness. I'm still trying to collect myself after panicking. And I realized that when I left the studio, the video I was hoping would play in the background, it doesn't work that way. So we've learned some things too. Marcus says we would have to invite Laura to the wedding. No, absolutely not. And just as I wouldn't invite some of my extraordinarily damaged family who would disapprove of such weddings anyhow, absolutely not. Laura would not be on the guest list. That's too bad. I would invite a bazillion other people long before Laura Owens to my wedding invitations. And that's just the way it shall be. So anyhow, let's get right into it. There's enough pages here that we'll see at what point Jeep Daddy decides to stumble in. And I still have to kind of get my act back together after leaving the studio and coming back in. So let's see, find that. Thank God my browser did not crash, or I don't know what would have happened. So here we go. This is the first item up for bid this evening, folks. This is going to be a David Gingras love fest. Mostly, almost exclusively. Because more has happened with the disciplinary hearing. David Gingras' war against the bar of Arizona. Some people just don't realize when they're playing the wrong hand, and I think he's one of them. I don't know if he plays cards. I don't play cards, really, honestly, truthfully, frankly, that could work too. I'm not the card shark. I hate cards. The math and all that stuff people do for cards, I don't care for it. I like more imagery and gameplay. Sitting there with little pieces of paper with numbers and symbols on them. So what? So the card shark gene passed me by. And that's why I don't play cards. But anyhow, what's that song? Know when to hold 'em and know when to fold 'em. I don't think David Gingras has figured that out yet, but that's just my opinion. Of course, he's entitled to a defense, and he's entitling himself to as much as he can possibly get away with, as he's wont to do. Yeah. Oh, of course, MD Thomas. How could I forget that? Don't forget Dave Neal's baby. Yes, little Augie, who's, I think, is in his terrible twos now, if I'm not mistaken. So, oh, yeah. How could we forget Dave and the whole baby moon and David Gingras and Laura Owens trying to ruin the baby moon? No, well, I can't think of everything all at once. Even with Jeep Daddy here, I tend to forget most things. It's okay. It's Friday. I'm not going to hold myself to the highest of standards. Yeah, highest of standards this evening. It's been a stressful day. The day did not start well, but we're here trying to recover what's left of the day with a little fun, frivolity, entertainment, some legaling, armchair legal speaking, because I'm not a legal scholar. I'm not a practicing legal person of any sort whatsoever, but we like to use what little intelligence we have to talk about these things that interest us. And it just so happens that things like this are interesting. PCB Amy says, I don't have a baby, but my puppy's first birthday is today. So there's that. Happy birthday. Happy birthday. Jeep Daddy is lurking in the chat. Yeah, well, he'll be on eventually. All right, so let's start with this thing. And I'm going to attempt to go chronologically. Let's see if I've succeeded in that regard. So this is more stuff for the douche canoe.
The fucking douche canoe.
And his embattled wager of war on the State Bar of Arizona. So this is before the presiding disciplinary judge, a Rule 58F3 ruling filed April 7, 2026. So, this thing's feeling a little stale already, but it landed very recently. And it says, this is just sort of a follow-up to something of what we've heard already. A telephonic status conference was held on April 6, 2026. The State Bar of Arizona was represented by Senior Bar Counsel James D. Lee and Craig Henley. Respondent David Scott Gingras was present and self-represented. A member of the public was also present, but was, at least for now, unidentified. The proceeding was audio recorded. Mr. Gingras filed respondent's notice of State Bar's failure to comply with disclosure rules. Notice. On March 30, 2026, which was the subject of the conference. Discussion was held. Mr. Gingras raised concerns with regard to the State Bar's initial disclosure statement and supplemental disclosure regarding a particular witness's testimony, and also indicated that he wishes to call Senior Bar Counsel Lee as a witness, given that he filed the formal complaint. The presiding disciplinary judge, PDJ, reminded the record of the requirements. Reminded the respondent, perhaps, of the requirements of Rule 5.2 of the Arizona Rules of Civil Procedure that were discussed at the initial case management conference. After discussion, the PDJ finds that Mr. Gingras' notice does not support a finding for sanctions under Rule 58F3 of Arizona Rules of Civil Procedure. The PDJ finds that Senior Bar Counsel Lee is not a witness in these proceedings, but rather lead counsel on behalf of the State Bar of Arizona. And for those of you who may not recall the details, David is trying to squeeze more stuff out of James D. Lee about MATA and about this and about that and all these little things. He wants to just worm his way into everything. And I don't quite remember the sanctions for some reason, but evidently he was also requesting sanctions against James D. Lee, representing Senior Bar Counsel for the State Bar of Arizona, for not disclosing all of those things, which, as you can see, the court found that it did not support such things for sanctions, and that the Senior Bar Counsel is not, in fact, a witness that David Gingras can call. Oh my goodness, K-Dubs, thank you for the 5. Dude, says K-Dubs, I've had a real stressful week. Been waiting for this all day. Thank you so much, K-Dubs. I've been waiting for it too. Yeah, I'll let the cat out of the bag just a little bit. I waltzed into work this morning and found a work vehicle had been stolen. So that's how my day started. that was the beginning of my Friday, was making a police report for a stolen vehicle. And this is a recurring issue for this poor work vehicle. And it's just no fun. It's no fun at all. But thank you so much for that, K-Dubs. Really appreciate it. And let's see. Okay, so State Bar Counsel Lee is not a witness, but rather lead counsel on behalf of State Bar of Arizona. It is ordered affirming an in-person hearing beginning on June 29, 2026 at 9:30 a.m. before the presiding disciplinary judge, Lisa A. Vandenberg, State Court Building, Hearing Room 109, 1501 West Washington, Phoenix, Arizona. It is further ordered affirming the telephonic final case management conference set June 18, 2026 at 9:30 a.m. dated the 7th day of April, 2026 by the Honorable Lisa A. Vandenberg, presiding disciplinary judge. Ah, yes. Oh, thanks, Wallace. Yeah, see, when it rains, it pours, and it's monsooning for me right now. And I've had it. I've had enough. As I told I shared this with Jeep Daddy this morning in a text, and I said, I'm so tired of this shit. I'm over it. I'm over all the work shit. It's like, I just want to retire. I just want to call it done. I'm done. I'm done. Oh, but by some will, maybe the grace of God or some other entity, either foreign, domestic, existent, or non-existent, I'm hanging together. I don't know how, especially for someone who's a teetotaler like myself. Jeep Daddy would have some sort of non-alcoholic insult for me, but he's not here yet, so that'll just have to wait. All right, that's document number 1. Let's go to document number the 2nd. Let's share that tab instead. Yes, so guess what? We've got more before the presiding disciplinary judge. Yes, we do. There's plenty more. I mean, golly, I feel like I need like some story time music. Maybe. I don't know. This might be too much. The antics of one Dingus the douche canoe. The presiding disciplinary judge, PDJ, has considered the state bar's motion for partial judgment on the pleadings. Motion filed March 9, 2026. The state bar's notice of errata filed March 9, 2026. The respondent's motion for leave to exceed page limits. Motion to exceed page limits. I love all these parentheticals. Okay, that's too much. Oh, Marcus says it's not too much. Well, I'm already over it. Let's see. Jeep Daddy says the following. Oh, good. He's worrying. Maybe he is worrying his bourbon stash. Don't worry, he says. I'm readying my bourbon, and he'll be here soon. Okay. Well, he'll waltz himself right in because he has some buttons too. So I'm sure he'll unceremoniously and as rudely as possible time his entrance just to be as annoying as possible because that's what he does. And now that I've provoked him even more, I'll keep reading. Let's see. The partial judgment on the pleadings filed March 18. Respondent's declaration of David S. Gingras in his support of his... Oh, God. Let's skip some of this. I'm tired of it already. So we were requesting to exceed page limits. It is ordered granting the motion to exceed page limits. That's nice. I'm not quite sure why they would want to do that, especially with him. But they've allowed it, so that's too bad. Because sometimes I think David just likes papering the courts. Just writing, word vomiting, finger pummeling a keyboard for as many words as he can put on a page. That's just my opinion. But he gets so verbose. I mean, the precision, the theatrics are absolutely right on point for him, but the precision that I like to see in good legal writing just isn't there. And for someone who's, a lay person and is not a practicing anything in the legal field, that says something. When I don't like it so much, because it's like, good legal writing should be practically boring. But his stuff is just overly dramatic. Hi, Great Grand X14. Welcome in. Nice to see you. Let's see. What else can we do? We need some more clown music. Oh, you know what? I'll save some clown music. All right, it's further ordered to the extent Mr. Gingras' request is for the PDJ to take judicial notice of the existence of various pleadings and or documents having been filed in the identified Superior Court paternity matter for the purposes of considering the motion addressed here and granting the request. That's interesting. Turning to the motion, response and reply. In the motion, the State Bar seeks judgment on a portion of the pleadings pursuant to ARCP 12C, as incorporated into disciplinary proceedings by the same sort of stuff as to the amended complaint filed February 25, 2026. Count 1 allegations as follows. 1, respondent violated Judge Mata's February 21, 24 order in violation of Rule 42, etc., etc., etc. Number 2, respondent's comments about Judge Mata were made in violation of Rule 41, B3, etc., etc., etc. The respondent has filed a response that objects to a judgment on the pleadings for numerous reasons. And here's the analysis. General consideration of motions for judgment on the pleadings. Regarding a motion for judgment on the pleadings, the court may consider as true such allegations of the complaint as are admitted by the answer. If these allegations set forth a claim for relief and the answer fails to assert a legally sufficient defense, plaintiff is entitled to judgment, etc., etc., etc. Let's see. Footnote says the PDJ has considered Mr. Gingras' citation of the unpublished federal decision. Well, why would they consider something unpublished? But I don't know. I'm not a judge. In discipline matters, the PDJ agrees with the State Bar that Arizona attorney discipline cases are sui generis, or sui generis. If I were to use proper Latin pronunciation, it'd be sui generis, or better Latin pronunciation. What little I know of such things. The proceedings are expedited and, therefore, by necessity, limited to issues relevant to the allegations of attorney misconduct. Rule 58J, Arizona Rules Superior Court. The PDJ considers the complaint and the respondent's amended answer filed on March 6, 2026, in its review of the motion and finds count one. Ahoy, Sir Moose. Good to see you, Bruce. Hope you had a good stream. I've been getting ready for this, so I haven't been able to see what you were talking about yet, Bruce. So I'll have to join the replay crew on that one. Oh, it's a raid. Okay, very good. It's a moose, magical moose, moose from the caboose raid. And Robin Richardson, your psychic girlfriend. Hi to you, dear lady afar. I've been enjoying Robin's psychic insights on some of the stuff lately, and it's it's a wonderful, fresh, and different take. And I don't know how she does it, but she pulls cards that just align with everything. So for what it's worth, go check out Robin's channel if you want a fresh and different take from a more metaphysical, energetic point of view. I'm not that intelligent when it comes to such things. I have certain abilities and awarenesses, but for heaven's sake, I can't quite read as well into the ether. But Robin can, and she is offering her abilities and expertise for yet another point of view in the Lawrence Owens cases. And Robin, of course, has been talking about other things as well that might tickle your fancy. So there you go. And I see, hey, Rob is here too. Hey, Rob, good to see ya. Hope you are doing well, sir. As this stuff gets crazier and crazier, sometimes I wonder if Arizona is going to sink into some volcanic abyss with all the craziness happening in Arizona. But what do I know? Alrighty, let's see. Count one. State Bar's alleged respondent violated Judge Modest February order. Okay, we read that part. Okay, Rule 42, blah, blah, blah. ER 3.4 is captioned Fairness to Opposing Party and Counsel. It states a lawyer shall not knowingly disobey an obligation under the rules of a tribunal except for an open refusal based on an assertion that no valid obligation exists. Emphasis added. ER 3.6 caption trial publicity. It states in A lawyer who is participating in litigation of a matter shall not make an extrajudicial statement that the lawyer knows or reasonably should know will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. So saying nasty things about a judge who gave you an adverse ruling and talking about things smeared on the bathroom stalls of the robing room webpage is perhaps not a good idea. Maybe that falls under the category of extrajudicial statements. My goodness, that could be. Let's move along. ER 4.4. Respect for rights of others. It states in A, in representing a client, a lawyer shall not use means that have no substantial purpose other than to embarrass, delay, or burden any other person, or use methods of obtaining evidence that violate the legal rights of such a person. That's very interesting. How many rights could he have possibly violated by submitting things? And he's going to make lots of First Amendment arguments, isn't he? Yeah, he's going to make all kinds of arguments. Let's see, Rule 54. Rule 54 is captioned grounds for discipline. Subsection C states, knowing violation of any rule or any order of the court. This includes court orders issuing from a state, tribe, territory, or district of the U.S., United States, including child support orders, emphasis added. The State Bar's motion points to the following paragraphs of the complaint and the respondent's answer as facts that satisfy the above allegations. Ooh. Paragraph 9. Respondent admits that the Maricopa County Superior Court case of... Oh my gosh, I hate it when they do that to my brain. The County Superior Court case in the matter of Owens and Eckerd was filed on August 1, 23, hereinafter referred to as paternity case. Paragraphs 24 to 5. Respondent admits that he was hired by Laura Owens in March 24 and filed a notice of appearance in the paternity case on her behalf March 25, 2024. Paragraph 41. Respondent admits that he knew of Judge Mata's February 21 order in the paternity case, stating, among other things, that no party shall disclose outside of themselves any medical or other documentation disclosed between parties. Paragraph 42.3. Respondent admits that he subsequently filed a motion in the paternity case, attaching a declaration dated April 1, 24, which was signed by him and included 3 medical records. Ooh, this is getting interesting. Respondent admits that his April 1, 24 declaration included references to the 3 medical records which were attached to the motion. Paragraph 47, respondent admits that he posted a Sonora Quest Laboratories medical record dated October 16, 23 on his law office blog on April 4, 24. Paragraph 49, respondent admits that he was immediately informed of the violation of Judge Mata's February 21, 24 order. Paragraph 52, respondent admits that he subsequently posted a portion of another medical report on his law office blog. I think that law office blog is going to get him in a little bit of trouble. Methinks, mayhaps. Paragraphs 53, 58 to 55 to 58, respondent admits filing a responsive document in the paternity case on April 26, which included medical records and summary portions of expert medical reports, which were prepared for the opposing party. Paragraph 59, respondent admits that he posted the April 26 response, as well as attached medical information and documents on his publicly accessible online X, formerly Twitter account, his law firm's website, and or other social media on April 27, 2024. Turning to Mr. Gingras' response, the PDJ agrees with Mr. Gingras if there are issues of fact properly raised by the answer specific to the alleged ethic violations, the motion should be denied. In response, Mr. Gingras argues that the portion of Judge Mata's February 21 order listed paragraph 41 conflicts with other orders such that it failed to provide Mr. Gingras with notice regarding the scope of the prohibited conduct. The PDJ considered whether such provides a valid defense to the filing in the docket medical records and the posting of such that Mr. Gingras submitted in his response. The answer nor Mr. Gingras' response reflect any indication that he took any steps to clarify the language in paragraph 41, even after opposing counsel sent an email indicating Gingras' posting was in violation of the February 21 order as reflected in paragraph 49. Oops. Such is problematic with regard to Mr. Gingras' ethical duties. However, Mr. Gingras points to filings made by opposing counsel after the issuance of the February 21 order that at a minimum present colorable claim with regard to Gingras' alleged mental state. Ooh, his mental state? Oh. Therefore, it is ordered the motion is denied with regard to the above listed allegations. Count 1. This is 2, count 1. State bars allege respondents' disparaging comments about Judge Mata violated Rule 41, Arizona Superior Court. Rule 41 is captioned Duties, Obligations. It states the duties and obligations of members, including affiliate members, shall be to maintain the respect due to courts of justice and judicial officers, and 7, to avoid engaging in unprofessional conduct and to advance no fact prejudicial to the honor or reputation of a party or a witness unless required by the duties to a client or the tribunal. Rule 42, ER 4.4. is captioned Respect for Rights of Others. It states in A, it is professional misconduct for a lawyer to In representing a client, a lawyer shall not use means that have no substantial purpose other than to embarrass, delay, or burden any other person, or use methods of obtaining evidence that violate the legal rights of such a person. ER 8.2. Caption judicial and legal officials. It states in A lawyer shall not make a statement that the lawyer knows to be false or with reckless disregard as to its truth or falsity concerning the qualifications or integrity of a judge, adjudicatory officer, or public legal officer, or of a candidate for election or appointment to judicial or legal office. Ooh, so disparaging comments about Judge Mata may not be a protected free speech because we've got ER rules that would say otherwise. And unless they file this all the way to the Supreme Court of the United States to strike down bar rules, this could be a problem, I think. I think this one could be a problem especially. Yeah. Oh, let's see. Oh, chat's talking about DUIL's DUI. Oh, go for it, chat. Get it all out there. ER 8.4 is captioned to misconduct. It states, it is professional misconduct for a lawyer to engage in conduct that is prejudicial to the administration of justice. That seems succinct. The State Bar's motion points to the following paragraphs of the complaint and the respondent's answer as facts that satisfy the above allegations. Paragraph 101 to 103 and 105 to 107, respondent admits making the cited statements regarding Judge Mata and the public, the contents of which speak for themselves. In his answer, defense respondent affirmatively alleges, I still hate that phrase, that he believes D in the truth of the statements and believes that these statements constitute an opinion protected by the First Amendment of the United States Constitution and by the Arizona Constitution. And let's see, then he argues that, the State Bar then argued that respondent's belief is disproven by, among other cases, following specific to attorney discipline, a bunch of stuff right there. And a bunch of stuff while respondent unequivocally admits making unprofessional and disparaging remarks about Judge Mata. Respondent again denies the conclusion that he violated the cited ethical rules. See motion page 6 through 7.
Did somebody say something about making disparaging comments?
Yes.
Oh,
Yeah.
goody. That's probably what summoned me.
I know. There's a lot. And we'll have to, I'm debating taking an excerpt of a video on a douche canoe blog that has been published this afternoon.
Oh.
That make disparaging comments. And dare I say, I consider some of those comments to be somewhat homophobic.
I heard this little tease in the beginning, and I was like,
yeah, and he even goes on to, in an attempt, a very poor attempt, very distasteful attempt at free speech, of suggesting gay activities between Clayton Eckert and his legal counsel, as well as talking about the Maricopa County attorney as calling her a cishet, something.
Oh, Jesus.
We're saving that for the end.
You wanted to make sure I was good and sauced, and then torture me with this in the end. That's exactly right. I know how this goes.
Yes, exactly. I know. IB says, yep, Jingy the homophobe. Big Bad Marcus is saying, show the homophobia. Show it so I can rage and leave. Nope, I'm waiting to the end. That's just the way it shall be. Because if I'm going to risk getting a copyright strike from David Gingras, I want it to be at the end. So it's easier to edit. If he decides to be so silly, which a very small excerpt of him poking at Clayton and Greg Woodnick and making sort of homophobic stuff, as well as Maricopa County Attorney Rachel Mitchell. We'll get to that. We've got a lot more to do first, so you'll just have to hang on or join the replay crew.
Yeah, let's get into it.
I've been reading up a storm already, and we're not even halfway there yet.
Oh God!
Well, the juicy one from Marc Randazza we're saving. I've got it pulled up, but that's next after we read his appearance. So Marc Randazza, free speech lawyer extraordinaire, has entered the chat for David Gingras, and why I will never know. Especially when we do the same stuff that Rant Zaddies bruised.
Yes, maybe.
Bruce just got off alive, so we had a little bit of a moose raid.
Oh, yes. I thought I saw all of the moose heads streaming across the chat here, and I was like,
see,
oh, God.
I'm too busy doing my job. I missed most of it, other than I saw Bruce's, since mods pop up in blue, I saw that. I'm like, oh, Bruce is here. Oh, so we must be done. Oh, look, there's a moose raid.
I noticed it while I was burning the shit out of my mouth with my dinner and then trying to fix my bourbon. So, yes.
I know. Well, at least you're ready to go. Oh, let's see.
As ready as I can ever be for trying to process all this shit from Gingras Gingras, excuse me, in my brain.
I know. Everyone's still getting it wrong, too.
It's pronounced gin like you drink and grass like you mow.
I will get a lot of mileage out of this one still.
I'm going to call him Gin Grass, if that's how he wants to be called, or dumbass, or dipshit, or
if you're
shit,
or if you're from the Isles of places like Sweden and Denmark and Norway, as Dick Starro calls him, ginger ass. Just with his accent, it sounds good.
Very good.
It worked, Mr. Ginger Ass, and he's got a cute little cat he calls Mr. Jingles. It's just funny. Dick Starro's kind of funny to me. They did their drunken stream earlier. Anyhow, let's see. I'm going to keep reading unless you wish to interject.
Oh, I'll interject. I will. That's just how I roll.
I've already talked about missing work vehicles and just how my day started. So that's out of my system.
Yes.
God.
Anyway, hello to chat. Lovely to see you all. Thank you very much for the warm welcome. Get your bourbon out. It's time.
Get your beverage of choice. It's happy hour. It's happy hour somewhere.
It's always happy hour somewhere.
And it's Friday. Happy hour should go to at least 2 a.m., right?
That should start at around 2 p.m., I think. That's a good 12-hour thing.
Okay, back to my paperwork happy hour.
Yes.
There's so much paperwork that's happened in the last 48 hours. My God. Turning to Mr. Gingras' response, Mr. Gingras does not challenge the State Bar's indication of his admissions regarding paragraphs 101 to 3, 105 to 7 of the complaint. Rather, he focuses his response specifically to what he describes as speech outside of the courtroom, making no distinction between statements made in motions before the court and those on social media. Yeah, that could be problematic. Especially when we're posturing as someone's legal representation. Regardless, Mr. Gingras seems to argue that Gentile v. State Bar is controlling and supports his proposition that disciplinary rules governing the legal profession cannot punish activity protected by the First Amendment, and that First Amendment protection survives even when the attorney violates a disciplinary rule he swore to obey when admitted to the practice of law with regard to free speech in the instant case. The PDJ disagrees. In the Gentile case, the subject lawyer held a press conference in which the Nevada court found he knew or reasonably should have known to have substantial likelihood of materially prejudicing an adjudicative proceeding. The U.S. Supreme Court found that the Nevada rule was void for vagueness. The court went on to state, moreover, this court's decision dealing, I should have quoted that, quote, moreover, this court's decisions dealing with a lawyer's First Amendment right to solicit business and advertise have not suggested that lawyers are protected to the same extent as those engaged in other businesses, but have balanced the state's interest in regulating the specialized profession against a lawyer's First Amendment interest in the kind of speech at issue, and in this case law. Next, Mr. Gingras argues that the Arizona Supreme Court has not, quote, published any decisions directly on the specific issue in the last 25 years, end quote. Footnote 4. Oh, God, the footnotes are long. Okay, we'll get to those momentarily. The PDJ disagrees and agrees with the portions of the cited cases above as provided in the State Bar's reply. As well, Mr. Gingras asked the PDJ to consider other jurisdictions' findings regarding his proposition, citing something out of Colorado. We talked about that briefly.
I think I remember that, yeah.
Yeah. In the Green case out of Colorado, the subject lawyer's criticism was based upon fully disclosed and uncontested facts, and thus, attorney could not be disciplined for making the statements. Emphasis added. Even if such could be considered as persuasive authority in the instant matter, other courts have declined to follow in Ari Green decision as well. For example, in matter of Marshall, etc., blah, blah, blah. I'll finish up the paragraph and then back up and see if there's anything in the footnotes. The New Mexico Supreme Court used an objective knowledge standard applied when determining if attorney statements about integrity of judge violated professional conduct rule after acquired evidence was immaterial in a case involving attorney who made unfounded statements about integrity of judge presiding over his case. Attorney did not have objectively reasonable factual basis to support his allegations of bias and lack of candor against judge. Attorney filed frivolous pleadings in violation of professional conduct rule. Since facts and circumstances as they existed at the time attorney filed his pleadings did not support his allegations of bias against judge, attorney engaged in conduct prejudicial to administration of justice in violation of professional conduct rule by making statements that undermine public confidence in the judiciary. Okay. Let's see. Response, page 16.
Here.
Footnote 3, the PDJ notes that Mr. Gingras has failed to identify any legal basis. Oh, I like it when they get this good. He's failed to identify any legal basis under which his specific written statements would qualify as protected speech. Maybe I should highlight that. That's good stuff.
That is good.
That's good stuff. Let's see. Oh, God, why is my highlighter not working now? Nothing's working tonight. Jesus.
I don't know.
Oh, it's just not fair. There it goes. God. It is well settled legal principle that constitutional protections on speech are extended to all speech. In State v. Brown, Arizona Court of Appeals noted that to resort to epithets or personal abuse is not in any proper sense communication of information or opinion safeguarded by the Constitution. Look, his things against Hey Rob are coming to roost back for him.
Mm-hmm. That's exactly right.
Isn't that great?
That's wonderful because, well, pay attention to your own shit here, man. And then let's just have that entire Hey Rob case just like evaporate out. Fuck that guy.
I mean, we've all stated our opinions on how we processed Rob's approach. Some people are fine with it. Other people disagreed. I'm a little bit more in the middle. Like, I can see both sides. I still believe there's freedom of speech, especially when reporting a case. And again, with Hey Rob's case, I believe it was more an attempt to shut him down and silence him than it was, he said something that's potentially threatening. Because really that was the bulk of it. He was so involved and he was present at the thing. I fear for my life. He's too close to me. He's watching my case. He's picking up filings. And then he got a little carried away.
A little. But yeah, the whole LO's reaction to the whole thing was sort of a typical mountain out of a molehill sort of thing, or mountain out of a freaking little piece of dirt on the ground. I don't know.
Yeah. And Rob even says, nice job, guys. I feel the proverbial nail has been hit on the head via the stream. I can say no more. Yep, we get it. But I find it a certain amount of sweet justice when someone's own arguments against Hey Rob are coming home to roost for their disciplinary stuff.
Mm-hmm.
I find it apropos, as some might say.
Apropops.
Yeah.
And to the little query there towards me from Robert, it's like over the top. That's kind of her specialty. All the reactions and everything that she's done when it's on camera are like, "Who are you? I don't even know who you are." When they're like doing the search warrant and everything like that, it's like just like that is her. That's what she does to try to make it seem like a much bigger deal.
I mean, just like her. Let's see. Do I have that on the just like this one?
I have done nothing except get pregnant by the fucking Bachelor.
All of that stuff was all performative on body camera. All of it, in my opinion. I mean, except for maybe the jazz hands where she was sort of freaked. It was like, oh shit, the police are actually here, and it's before 7:00 in the morning. It's like, yeah, look, there's police, and there's like a SWAT team on your property. Hello.
Yep. Anybody home upstairs? The answer is no, obviously, but
Oh, let's see. What else? Hi, Minnie. How are you doing? Welcome in. Good to see you. Wallace says she's permanently in carrot mode. I like that. And Rob says
whiny baby mode.
Rob says that's a false statement, as we've learned. Correct. Which one? I'm saying so many statements I can't keep track of them. It's okay. It's all right, Rob. You don't have to explain things. It's okay. I'm too busy thinking about paperwork that I'm trying to read here, and I don't want to backpedal too much to stuff that's under the bridge, unless it gets really interesting or related. Because I still think Rob got done dirty in his defense. The statement. Oh, yes, the statement is that she got pregnant by the Bachelors. We've run.
Yeah,
wasn't true.
well,
Yes,
that is well known, established fact at this point.
Yeah, it is a matter of law, as decided in the paternity court, that she was never pregnant by the Bachelor, because they issued him a favorable ruling of non-paternity because she didn't remotely reach her burden of proof to have proven that she was pregnant by the Bachelor. So that's why she owes Clayton about $250,000 now, after all this bullshit. And if some of the stuff David Gingras tries poorly to make fun of is Clayton shirtless, bless him, singing a little bit of the Love Trap song and changing some of the words that Laura has to pay him now.
I wasn't sad to see that.
No, that was it's like, if only Clayton were gay, I would shoot my shot, but I wouldn't get anywhere. He's so tall.
Neither would I. Well,
he's so tall.
Everybody's
like,
tall to you. Everybody's tall to you.
It's true. He's probably, I think he's taller than you even.
Oh, well.
Yeah. Because he's like 6'4", 6'5".
If that's the case,
something like that. He's
2 or 3 inches on me.
Maybe more than that. I forget. He's some tall beanpole. It's like,
It's fine if he wants to. I'll gladly measure our height.
What?
Well, I thought it.
There have been no inferences on anything regarding what Laura Owens performed and any sort of physical specifications.
Measurements are complimentary in Deep Daddy's house. Let's just put it that way.
It sounds like he's no slouch, but that's supposition. I have no proof.
Look, no thanks. I would absolutely climb that. Okay, let's just be real. And I'm a tall guy, and I would fucking climb that. So yeah, here we go. Yeah, it's either spicy or salty. Jeep Daddy, there's a rant coming at some point. I kind of already had a couple mini ones. I'm just getting warmed up here, folks. I'm just getting warmed up.
He's only the first glass in. Give him a chance.
And it's the big one, so because
you'll get there.
Go big or go home.
About 30 minutes. Let's see, where were we? The next New Mexico Supreme Court used an objective knowledge standard applied when determining if attorney statements about integrity of judge violate professional conduct rule after acquired evidence was immaterial in a case involving attorney who made... Did I read all this already?
I think you read that one, so let's...
Okay, let's skip ahead. I think I already read it and my finger twitched.
You did.
Given Mr. Gingras' stated position regarding his speech outside of the courtroom, the PDJ notes that a portion of Mr. Gingras' written statements at issue here were in a court pleading in a case in which he represented a client. Maybe I should get... There we go.
All right.
I hope the buttons still work.
Yeah, at least in the beds they're there.
Damn StreamYard. I can't believe
I was furiously trying to log in early and because you were muted and I was ripping open my laptop earlier and oh my God, I got to tell him because nobody can't hear nothing and
I should ask, did any of the intro audio play?
Yes.
Oh, that's bizarre.
Yep.
That's bizarre. Okay, it's a StreamYard issue. I'm just not even going to think about it.
Yeah.
Sometimes you just have to leave the damn thing and come back in, and that's just the way the only way it works.
As they say in the IT crowd, did you try turning it off and turning it back on again?
I know. It's true. I don't know why.
It is true. It is true. It is, yeah.
You got to whack the ones and zeros upside the head with a power off moment, and then they behave again.
Sometimes.
I think it's, what was that phrase? Free radicals when it comes to neurology, where just a synapse goes and the whole sequence just gets messed up. I think similar things happen in computers.
I mean, they're not, there's so much going on all at once. It's kind of hard to, sometimes things collide. Sometimes streams get crossed and that's just enough to just fuck it up enough that I can't see the audio now or something. It's just,
Yeah, it's just a lot. It's ridiculous.
Just wait until AI takes over your operating system and then And then it's going to hallucinate its way into like not letting your microphone go off. But that's another
dear.
rant for another day.
I don't want AI taking over physical buttons. I know it's coming and I'll have no choice, but what do I do until then?
Bitch and complain about it.
Yeah,
And
that's about all we got.
read about stupid lawyers making stupid decisions and stupid filings with red ink.
Red ink. Oh dear. Unprofessional conduct during the practice of law may result in the imposition of discipline pursuant to Rule 41, etc., etc. Unprofessional conduct includes substantial or repeated violations of the oath of admission to the bar or the lawyer's creed of professionalism of the State Bar of Arizona. The oath of administration to the bar provides, in pertinent part, that lawyers will treat the courts of justice and judicial officers with respect. 2, will avoid engaging in unprofessional conduct. 3, will not advance any fact prejudicial to the honor or reputation of a party or witness unless required by their duties to their client or the tribunal. And 4, will at all times faithfully and diligently adhere to the rules of professional responsibility and a lawyer's creed of professionalism of the State Bar of Arizona. I wonder if he crossed his fingers when he took this.
Behind his back. Yeah,
Yeah,
just like,
exactly.
Oh, just kidding.
The creed of professionalism of the bar requires lawyers to conduct themselves in accordance with the creed when dealing with clients, opposing parties, opposing counsel, tribunals, and the general public. Lawyers must be courteous and civil, both in oral and written communication. In negotiations, depositions, and other proceedings, they are to conduct themselves with dignity and not be rude or disrespectful. Our Supreme Court has found within the last 6 years that Rule 41B is not merely aspirational. In Martinez... let's see. Oh, that's just citing that one. See, diligent and competent representation of a client does not require or justify denigrating, disrespectful, belittling language. See, in that case, respondent says that he would not have behaved as he did if the judge acted properly. Regardless of respondent's belief that his actions were necessary to protect the client's interests, his behavior was inexcusable. Florida Bar v. Norkin. Attorneys should focus on the substance of their cases, treating judges and opposing counsel with civility, rather than trying to prevail by being insolent toward judges and purposefully offensive toward opposing counsel, like saying Clayton Eckert and Greg Woodnick engage in gay sex, like he did today. We'll get to that.
Oh, that's gonna be good.
We'll get to that. I will take a little bit of risk to play that little chunk.
We're just reacting to things, right?
Yeah. Sadly, yeah. Okay, good. I'm just checking to make sure it's still queued up. God. Oh, let's see. Oh, I can get rid of a tab. Good. Let's see. Further, the PDJ finds that Mr. Gingras has not asserted that the language quoted in the complaint that has been conceded was objectively and reasonably necessary to advance his client's matter. Assuming arguendo. Oh my God, I love it when our lawyers talk arguendo to me. I find that gets me a little hot and bothered. Give me some arguendo. He had effectively done so. The U.S. Supreme Court has indicated in Nix v. Whiteside, an attorney's ethical duties to advance the interest of his client is limited by an equally solemn duty to comply with the law and standards of professional conduct. As well, our Supreme Court has found in Bemis that disagreement with legal rulings does not justify oh my God, it's a word I haven't seen before. Vituperative attacks on the judiciary? Am I saying that correctly?
I'm sorry, wait, what? I was busy looking. Oh, look at that.
That one.
That word.
Vituperative? Vituperative?
Vituperative. I gotta look up all these, like,
oh my God, this is like
words.
a $100 cocktail word.
Yeah, no kidding.
Ooh, would you look that up for me?
Vituperative. American English, it doesn't have anything, but
I like it.
British English, it says bitter and abusive. Vituperative outburst, as an example. But yeah. I mean,
I think that describes David Gingras' commentary on most of this.
I mean, Bruce, it was too expensive for my American dictionary, but my British dictionary apparently is sophisticated enough for that.
Oh, I love it. We've got some new
great
vocabulary.
Word. Jesus Christ. All right. Well, I feel like I'm getting all edumacated here.
Well done, PDJ, giving us some extra vocabulary this time. The court is most concerned with respondent's refusal to accept that his conduct cannot be justified by any perceived unfairness in the judge's rulings. As the commission noted, this matter was the result of his misguided, overzealous efforts to obtain a successful result for his clients. Respondent must realize that zealous advocacy has limits. It clearly does not justify ethical breaches. Oh my.
Here's our pronunciation guide.
Ooh, V2 parative.
V2 parative.
Thank you, chat.
Thank you.
I was close. I was getting there. Let's see, what does Bruce say? Bruce says maybe David can win his appeal if he uses British law to get his Rule 26 safe harbor. Let's see.
Maybe.
The PDJ finds that Mr. Gingras has admitted the conduct described in paragraphs 101 to 3, 105 to 7, and has failed to present a valid defense. Okay. This is important. We're making findings here. And failed to present a valid defense with regard to findings of those rules, blah, blah, blah. These findings shall proceed to an aggravation and mitigation proceeding at the appropriate time. But that's not all of it, which is why they're going to have a 4 or 5 day hearing. Therefore, it is ordered granting the state bar's motions for judgment on the pleadings in part with regard to paragraphs that, and the other of count 1 of the complaint, finding respondents submitted comments about Judge Mata, and they violated the rules there. It is further ordered that the state bar file the appropriate pleading or notice in the record within 5 calendar days of this order, indicating whether the state bar intends to proceed on any outstanding allegations in the complaint or moves to dismiss the outstanding allegations, requesting that the evidentiary currently set be vacated and the OPDJ to reschedule the matter for an aggravation and mitigation hearing on the admitted violations only. So it's a question. Dated 14th of April 26 by the Honorable Lisa A. Vandenberg, presiding disciplinary judge. See, please note an unfinished version of this ruling was this talks about something he talked. He was kind of gloating on this for a second. Please note an unfinished version of this ruling was mistakenly sent via email to the parties on April 8. It was withdrawn as soon as the error was identified. PDJ and OPDJ apologize for any confusion that said email may have caused either party. The above is final and official ruling on the pleadings referenced. Okay, that's interesting. And, of course, it was sent to the usual people. Alrighty. Now, we get into the appearance of one Marc Randazza. Okay, fine. I'm getting weird dialogue boxes that I don't need right now. So now, ladies and gentlemen, let's see. I wish I had an actual drum roll, Here comes the cavalry for David Gingras. Marc Randazza, free speech attorney extraordinaire.
I mean, it is kind of apropos that it is the Rite of the Valkyries you're playing there. That's the
They don't have
one of the
many
most
options.
well, yes, but it's one of the longest and most drawn out things that could have ever it is way too long and blowhard music version, just like these people are. Well, yes, there's that too. But,
Okay, better not play too much.
Don't get copywritten. The mouse will come after you.
Oh God, the evil mouse. The evil mouse. Okay. Notice. See, this drives me crazy. Notice of limited scope appearance. So it's not full representation. It's limited scope appearance. We're going to bring someone else to, stomp around in the mud and make more filings. Why not? Why the hell not? It's only taxpayer dollars, folks. It's only your taxpayer dollars in Arizona paying for
hard at work. That is correct.
For the Arizona bar and the presiding disciplinary judge, who, if I'm not mistaken, are paid by taxes to respond to all this nonsense.
As far as I know,
it's just
the
wild.
judges are.
Undersigned counsel Marc J. Randazza, Esquire, pursuant to Arizona Rules of Civil Procedure, hereby gives this notice of limited scope representation and appears on behalf of respondent David Scott Gingras as follows. I'm using his middle name now, too, because it's Laura Michelle Owens. Seems only fair that if it's Laura Michelle Owens, it should be David Scott Gingras, right?
I mean, does he have to
Hey, Rob
clarify the
says,
pronunciation of that name too, or yeah?
I hope not. Hey, Rob says, you mean my
Yeah.
taxpayer dollars,
Sorry,
right?
Rob.
Yes.
Yes.
The taxpayers of Arizona. I would start filing complaints about, the multiplication of proceedings for disciplinary hearings of disenfranchising attorneys. Okay. Is that the right word, disenfranchising? That kind of works.
Sure.
Let's see. So he appears on behalf of David S. Gingras as follows. 1. Undersigned counsel's appearance in this matter shall be limited in scope to the following matters, hearings, or issues. Filing, briefing, and arguing if ordered, a motion to dismiss pursuant ARS, and in the alternative, a motion for summary judgment, including replies if any. So it's not much.
That's pretty limited.
Especially now that there's a partial order on the summary proceeding, the thing we just read.
Yeah. But,
So the
okay.
job's partway done already. This seems kind of pointless then. Number 2, undersigned counsel hereby states that he and respondent have a written agreement that the attorney shall provide limited scope representation for the purpose of representing the client in this court, and this notice accurately represents the scope of that agreed representation. Signed, Marc J. Randazza, submitted April 14. Randazza Legal Group, LLC, PLLC, Las Vegas. Yeah. And that's it for that one. So that's a nice short one. We like short ones.
Mm-hmm.
Statement of undisputed material facts. What is this thing? These just keep going. See, that one can go. That one can go. Prevent this page from... I just want this one to go. That one needs to go. Okay.
I have no idea what you're grousing about other than probably...
No, I'm getting
prompts
pop-up
from you.
things that say, oh, do you want to close this thing because it wants to ask you other questions? Like, no, I don't want it. I'm done with that one. Go away.
Oh.
A statement of undisputed facts. I think a lot of this is going to be about the paternity case. Why
So we're
that's
just going to
relevant
blather on more and more and more about the
Yeah.
same old shit over and over and over again?
We
Okay,
might
cool.
skim through this one real fast because it may be mostly Owens v. Eckerd. At least that's what I thought I saw. David Gingras submits the following statement of undisputed facts. Affidavit of David Gingras, request for judicial notice. Laura Owens filed a pro se paternity issue, Owens v. Eckerd. There was a response, motion to seal court record, court administration. Attorney Greg Woodnick filed a notice of appearance. Yeah, this. Why are we relitigating Owens v. Eckerd in this nonsense? Why do we even? What's the point? Well, Judge Mata didn't say what Judge Mata said, so therefore I shouldn't have any discipline, even though he admitted to things. And now we've got a partial order on the the summary judgment.
Yeah.
Order the summary on the proceedings. Motion for leave to amend response. Ms. Owens moved to dismiss. Woodnick filed a motion for sanctions. Ms. Owens filed a motion for confidentiality. Woodnick filed an objection. Yeah, this is all Owens v. Eckerd crap. Why do we need this? This is about his discipline, not the case. So annoying. Order denying Ms. Owens' motion for confidentiality. Denying petitioner's oral motion for confidentiality. Let the record further reflect no party shall disclose outside of themselves any medical or... I mean, what's this going to do? It's kind of proving the state bar's point.
Kind of.
I would think someone of Marc Randazza's ensconcement would be a little more focused.
You'd think there'd be a little more with it, but I mean, I don't know. I don't know. I need somebody smarter than me to tell me why all of this repetitive restating all the things like 12 pages long is gonna... But I just... Somebody else explain it to me because I just simply
What
can't.
is going on in chat? Is there talking smack going on in chat? Don't make me pull this car over, chat. No, as they say in other channels, you can't let chat do chat.
something about coffee and smelling shoes and feet or something. I don't know.
And Bruce can't swim in pools. Oh, I don't know if that's true.
I mean, To each their own.
Okay, I'll keep skimming. Respondent was retained to represent Owens in March 25th. Respondent was retained. No, I asked for protective order multiple times. The judge, yeah, Laura Owens wanted to make it a sealed case, which was stupid. No protective order had entered. Reviewed the document. The statement was correct. In his pleading opposing Miss Owens' request for protective order, Woodnick argued impermissible prior restraint for protected speech. Lots of arguing. Toothpaste can't be put in the tube. Premature to designate confidential documents. Blah, blah, blah. Or records that do not exist have yet to be produced. February 21, order issued by Judge Mata did not contain written findings of fact and conclusions that the specific sealing or redaction is justified, nor did the order contain any finding there exists or overriding interest in overcomes right of the right of public access to record. Mr. Woodnick sent respondent email stating, I'm also not certain why you're publishing documents in your client's personal medical records contrary to the court's order. And a complaint. There was an email. If you interpret the order to mean Laura is somehow enjoined from publishing her own records for the purpose of responding to false statements other people are making, you need to let me know that immediately so I can take the issue up with the judge. So their position is that Laura can release her stuff to beat the internet over with a stick if she wants to. That's their argument, even though the judge said no one should be disclosing anything outside of the parties. That's a weird argument to make.
But that means either parties, not just because it was LO's records. Like, let the case finish itself out, and then you can post all your personal shit on the internet you want to. I don't advise it, but like, do what you want.
And I know, Jeep Daddy's just sort of complaining that I'm reading all this stuff, but he didn't put anything into the chat GPTs himself, which he could have. Although you said you had there were show notes, but I couldn't find any. So we'll have to talk about that later.
Yeah, we'll figure that out later. I don't know.
Did
you have show notes?
No, I didn't put any in.
Well, then I didn't either. So
okay, I thought you said that there was something.
I just sent you the link to the page. I didn't say I had anything in there.
I actually have the thing as an app on my toolbar now, so I can actually just open it up.
Yeah, there you go. See, that's
I don't have it on my phone yet, so that's a problem when things happen during the day and I'm not at my computer. I'll fix that problem later.
Because I'm always because you're busy filing police reports and belly aching to me
it's
a little bit
such a pain
about
in the ass, and there's such contradictory information. The city says call 911, but of course, when you call 911, dispatch says call the non-emergency number. We're busy. This isn't important enough.
Yeah, why the fuck would you call for a stolen vehicle? Why would you call 911 for that?
Well, I've done it once, and I learned that lesson 3 times ago. Don't call us, just call the non-emergency. But the city says to call 911 if it's a vehicle theft. I don't get it. Someone needs to correlate some stuff on the city website.
Yeah.
But I already knew that. So I did not call 911. I called the non-emergency. I still had to wait 24 and a half minutes before dispatch picked up the non-emergency line. And then I got a call from an officer, and that was like 3 hours later. And actually, I got footage from the building owner that shows it being drug away by another very similar vehicle and two people getting into it, including someone with a backpack and bicycle.
No kidding.
Yeah, it's not clear enough to see faces or plates of the offending vehicle that helped drag our vehicle away. But at least you see something happen. There's a date and a timestamp and that kind of thing. But it was in the middle of the night, 1:18 a.m. The footage isn't the best quality, so I don't know if they're going to take it as evidence or not.
They may not, but at least it's good enough for it's good enough for what we would call a left goalpost, which is like, well, this is the time that this happened.
Information, yeah. So I'm not going to deal with it anymore this weekend. I don't care if they find it because I know the steering column's smashed already. We heard the audio of it getting smashed as they were ripping it off. So it's like, well, we can't even deal with this with the business right now. So if they find it, fuck it. I'm not going to deal with it over the weekend. It can wait till Monday because it's going to be trashed. And what am I going to do with it anyhow? It may not even be drivable.
Yeah, maybe not, but that's fine. I'll grab a trailer and my big ass truck and we can take it to the scrap haul yard. I don't give a shit.
Bruce says he picked up a random document, went live, and made coffee, and not even in that order. Oh, touche. Bravissimo. Let's see. Okay, so we're just rambling on about case stuff. I'm just going to fast forward.
Yeah,
this is all Owens the Eckert
of
rambling.
Yeah.
Blah, 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 blah. In response to Ms. Owens' request, okay, so this keeps going. Maybe I should play some hold music while I skim. This might be a little bit interesting. Prior to accusing Judge Mata of violating the Code of Judicial Conduct by considering extrajudicial evidence, respondent undertook extensive research to determine whether that statement had a reasonable basis. We're talking about the Planned Parenthood thing. The steps taken include ordering an expedited copy of the trial transcript, which Judge Mata falsely attributed testimony to Dr. Deans. The respondent further asked his wife and Miss Owens to separately review every pleading. His wife? Mrs. Gingras? No.
I'm saying, wait, what? I was not expecting those words.
Neither was I. Respondent further asked his wife and Mrs. Owens to separately review every pleading from the docket in Owens to determine if the issue of Planned Parenthood's business hours was discussed in some earlier pleading. Both Miss Owens and respondent's wife concluded that Planned Parenthood's business hours were not discussed in any pleadings filed in Owens prior to June 10, 24. In addition to asking his wife and Miss Owens to review every pleading from the case, respondent personally reviewed every pleading filed between August 1 of 23 and June 24. That review confirmed the Planned Parenthood business hours were not discussed in any pleadings filed in Owens. So what? And that's the end of the document. Okay, we can move along. You're going to hate this one. You're going to hate this one.
Are you going to try and force me to read it, or?
It is your turn to read. We may have to skip because it is 48 pages.
Oh my God. I don't have the right glasses for this. So if you want me to read something, I've got to go get my computer glasses.
Brought to you by Randazza Legal Group, PLLC, in the matter of David S. Gingras and the State Bar of Arizona. I'll start. So if you wish to find other spectacles, you may.
Fine. Be right back, chat. Oh my God.
Do we need do we need on hold music for you?
You can do whatever you want. Enjoy your time at the apothecary.
No, I can get started. We don't need to do that silliness. From Randazza Legal Group, in the matter of David Gingras versus the bar, pursuant to ARS, respondent Gingras respectfully moves for an order dismissing this matter with prejudice. Of course they do. Of course they do. What else would they be asking for it other than for it to go away? Dismissal is required because the complaint contains claims which arise from state and federally constitutionally protected speech and petitioning activity, and the state bar cannot meet the burdens required by ARS. But yet we've got a partial order already. Oh my God. Hey, guess what? I think you've got maybe it's to everybody. Oh, well, thank you, Bruce, the Moose, for the 20. Car Fund, beep, beep. Oh, Bruce, you are too sweet. That is extraordinarily generous of you, sir. Thank you so much.
Thank you so much, Bruce.
I think we want to just total the thing. It has been stolen 4 or 5 times now. I think 4. As memory serves. And all within the last few years. It's become an epidemic, and I'll be indiscreet and say it tends to happen when there are unsheltered and unhoused people of a certain quality and class in the near vicinity. Whenever those encampments find foothold, we start having issues. Every time. Every time.
Mm-hmm.
It's just, it's frustrating. It's unfortunate, and I would like to sue the city for not dealing with it. But I know I would lose that battle. Thank you again, Bruce. Let's see. Dismissal is required because containing Respondent further moves for an award of costs of including attorney fees and damages, including lost income. Lost income from what?
Okay.
Unless he's got other cases, he's only been playing around with Laura. I don't know. I haven't looked him up. I don't want to spend the money to see if he's doing any other cases. Maybe someone knows in chat if David is doing any other work other than flapping about pro bono for Laura Owens. I don't know. I think he did have a case with somebody down in Florida that he was co-counsel on, but it didn't sound like a very long-term thing.
I mean, if his blog is any indication, that's all he's been doing, because that's all he talks about is this fucking case or all of these like related cases to that. So
maybe. Michelle says maybe Illo stole it like she steals ultrasounds. I sure the hell hope not. No. The video footage, because there is video footage. There is genuine security cam, not body cam, but security cam footage of what appeared to be a bunch of males stealing said vehicle, including one with a backpack and a bicycle, which tends to also be part of a certain class of street dweller in this area. So, do with it what you will. And we made it very difficult for them to do so. But, you smash the steering column, you find another vehicle to pull it away, and you can take it. But
everything is theftable, right? Like,
yes. If you really want it, you'll find a way.
Only keep out honest thieves. Let's just be real about that. So,
yeah. Yes. But anyhow, okay, I need to stop talking about that stupid thing. In the alternative, let's see, in an amount to be established by affidavit. So he's going to claim he's got lost wages in an affidavit. Is he going to try and recoup what he gave Laura for free through this too?
I'm going to recoup my $0. Thank you.
Well, what else could there be is my question. So that'll be interesting to see. In the alternative, and solely if the court finds ARS inapplicable for any reason, respondent moves for summary judgment pursuant to that stuff. Summary judgment is proper because no material facts are disputed, and respondent is entitled to judgment as a matter of law. Oh, I think he'll get a judgment, all right. IB asks, so Jingy has income to lose? ? Well, so he says. If he's doing things pro bono, I'm not sure what income there is to lose. I mean, it was sort of like the whole thing with Rob, where he was doing it pro bono. He said so. It's like, well, if he's doing it for free, how can he ask for even reasonable attorney fees if he's doing it voluntarily and for no cost? I don't understand that.
Yeah, I don't get that either. Just the math doesn't math.
It just seems convenient trying to make a buck.
I guess. How does one get fees back from doing free pro bono work?
Yeah, well, he did. He did. At least with poor Rob.
Okay.
I assume they decided just to pay that. I don't know if they're going to fight it. Rob didn't say anything. He doesn't have to. It's his case. All those things, it's up to Rob what he can and cannot share. Respondent is aware that there is an issue. Try that again. Respondent is aware the PDJ recently issued an order granting judgment on the pleadings with respect to a single issue. Actually, I think it was more than one issue. I think it was 2 issues. That order did not mention, nor did it resolve respondent's defenses under ARS or the U.S. constitutions, etc. To preserve those issues, this motion will raise those arguments even though the court may consider them to have been resolved by the prior ruling. How?
What? Okay.
This is like the motion for the motion to reconsider, the motion to reconsider, the motion to reconsider kind of nonsense. All of mirrors.
Yeah.
We want to make a motion to complain about this, even if the court has already ruled on it. Yikes. Let's move along. It's hurting my head.
It's hurting mine.
We're only an hour and a half.
This is why I drink.
I think that would make my head hurting worse.
Actually, no, I just like the taste of it. The getting the dogs to start stop barking in my head is only a pleasant side effect of the good tasting shit here.
Yeah. In this case, the Arizona bar seeks to discipline David Scott Gingras for activities that are protected under the right to free speech and the right to petition. Oh. I can't say what I'm thinking. I can't say it. I can't say it. I cannot say it. The bar's position is inconsistent with the First Amendment. But even if it were, well, that's a nice conditional. Thank you. I think they will decide. The Arizona Constitution would not tolerate the bar's positions. Wow. Why does this feel like spaghetti?
Arrogant.
Well, supposedly Marc Randazza is quite the cock of the walk, if you know what I mean. That's the reputation I gather.
Yeah. So it would seem. I mean, these are some pretty bold-ass statements.
If we take this to the Supreme Court of the United States, half the bar's rules will be struck down.
Uh-huh.
I think they would have been by now, quite frankly. Wallace is asking you a question.
I just noticed. Yes, Wallace, I drink some scotches as well. One of my favorites is Lagavulin 16-year. Not the 9-year, not younger than that, but the 16-year. I could put that down. And that's probably about the peatiest of the scotches that I much prefer. But there's the Glenlivets and the Glenmorangs of the world that are absolutely pleasant, and I would not shake a stick at any of them either. So yes.
For those of you who have the bingo card this evening, whiskey chat is can be ticked off now. I think I need to start making. I think I need to start making bingo cards for each live session. Jeep Daddy rants, whiskey chat,
eye rolls,
bingo options.
Yeah.
Other than boomer tech problems.
But you're not a boomer.
Neither is Megan Fox, but she has boomer tech problems. The Arizona Constitution provides broader guarantees than the First Amendment. See case law. The words of Arizona Constitution are too plain for equivocation. The right of every person to freely speak, write, and publish may not be limited. Yeah, this,
hey,
I think
Toadette.
we're filling every piece of. Oh my gosh!
Thank you. €6. Awesome. Thank you. That's awesome.
Oh, thank you, Toadette, for the European. What we got? See, like I've got Canadian pesos. I need something for euros.
I don't.
I'm gonna have to workshop that one.
Yeah.
IB says we need a bingo card. I know. See, I need someone to help me do some stuff. We need some bingo cards.
As long as it's just it's not a bingo. It's got to be a bingo card because it can't be a drinking game because we would all be stone flat fucking drunk by the end of those. Any one of these random readings. But I mean, you do you. Obviously, I'm sitting here drinking and all that. But hey ho, like
I'll have to start working on some bingo cards.
Yeah,
I'm not going to do a wheel of. I'm not going to do a wheel of regrets like Nick Starro because I can't handle that kind of thing. Maybe Jeep Daddy can, but I'm not gonna. So I have limitations. I do.
Look down on what?
Huh?
What are you talking about?
Huh? What? Oh, it's a super sticker. Oh, sorry. It's not a super chat. It's a super sticker from Toadette. I'll learn how to read these eventually.
It's all new territory.
It is. It's all new. Gag order, blah, 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 skipping. Nevertheless, even if this tribunal were to ignore the Arizona Constitution's higher levels of speech protection, the First Amendment and Gentile v. State Bar of Nevada and its progeny would roundly reject the bar's positions in this matter. That's just all contrarian arguments. This case arises from a high-profile paternity matter. Called Owens v. Eckerd, this case drew immense public attention because the respondent in this case, Clayton Eckerd, is a if you have mentioning Clayton Eckerd being the bachelor on your bingo card, you may not tick that one off.
Yeah, you may not tick that one off. Yes, exactly. And Jupiter Janes, thank you so much for the the $5 there.
Thank you, sir, for the Canadian pesos. See, we've got Canadian pesos. We like Canadian pesos.
Love Canadian pesos.
Sarah says, I just happen to know her name, so because she's identified herself as Sarah in chat, so it's not doxing. I don't think.
All right, okay.
She says, happy to be awake for live. Thanks to Echoes and that other guy there.
And if he did dox her, she's probably going to take that $5 back.
She's welcome to, but I identify her as Sarah in chat, and she hasn't smacked my pee-pee. So
Okay, well, good.
and I think she's waiting for Bruce to propose to her.
Oh,
I think I may be wrong.
Huh.
Sometimes I see indications of that in chat, just like Marcus keeps flirting with me and says he's going to marry me in chat.
well, Marcus needs to get vetted by me first. That's all I'm saying.
Oh, I know. I said, well, if you got to put a ring on it, or at least take me on a first date.
That's right.
Yep.
And you're
going to be hiding on that first date.
And then you're going to have an interview at some point later.
Oh, I know. See, this is how we need to do that. Any prospective potentials, there needs to be,
I'll just be like a few tables over. It's no big deal.
Bruce says Jupiter is her only antler's name. Yeku, hey, good to see you. Says if they find that he should be disbarred, won't they be saying that he is not fit to be getting any fees as a lawyer? That's a good question. I would wonder that myself, but oh my gosh. From Wallace Juno. Thanks for the 5 Canadian pesos too. Make it rain pesos. We don't need it. We don't need it. I don't have my water wings. It's too early. Far too early. But thank you for the 5.
Yes, thank you.
This case arises from the... Okay, I've already read that. Oh, we talked about The Bachelor. This is good. This is good. I read this part earlier.
Oh, all right.
As is common in such high-profile cases, it drew an army of spectators, not just in person, but online.
Oh, no. Okay.
This online morass of attention and harassment created a bit of a circus. What harassment?
Okay, that's cute.
What? Exposing that this woman is a fraud who's engaged in paternity fraud and is being charged with 14 criminal felonies for various forms of fraud is harassment? Piss off.
Yeah, piss all the way off.
Jesus. It created a bit of a circus and appears, oh God, it gets worse, and appears to have excited the judge who did not appear to handle the public attention with the greatest degree of care. Holy fuck.
That's a cute theory, but...
Tee-hee, look at me, Daddy. I'm a real judge now while I rule. This comes back to all that crap.
Yes, and this notion, like every accusation is a confession. Yes, they're making a circus out of it. Yeah, y'all are making a fucking circus out of it. Knock it off. Sit the fuck back down in the chair.
This comes back to perhaps the judge's sister watched some of The Bachelor. There go. It's all conspiracy.
Oh no! Somebody watched something on broadcast television. God damn.
Oh my lord.
So stupid. I'm just getting warmed up. See, there's a couple little mini rants in there. Here we go. Yep.
I'm going to have a coronary if I get too excited.
Jesus Christ.
See the request for judicial notice, which was the previous document I skimmed through, which I don't care about because it's just rehashing stuff in Owens v. Eckerd. Respondent, in representing his client, determined some of the judge's actions were tainted. But he had no facts. He made allegations.
Just made shit up.
There were allegations or no facts. And there are also no facts. I think what would it be? A preponderance of the evidence? Because he went to the what did he go to? The presiding judge for the division. That's the presiding judge. The head judge for Judge Modest's division. They went there and they said, nope, there ain't no there, buddy. Knock it off. Because he was trying to get Judge Mata kicked in a retrial. For those of you who want to go back in the time machine. Oh my God. For example, the judge made a finding, and now here we're going to talk about the Planned Parenthood thing. The judge made a finding of fact that was not based on any trial evidence, but was raised on social media after the trial ended. See RJN. Okay, so where's the free speech problem there? I mean, we're arguing that this is all free speech, but where's the free speech issue? Oh my God.
And they're bitching about anonymous trolls on Reddit here. Like,
Oh yeah. And the great amount of attention by anonymous trolls on Reddit, a notorious online cesspool. I love this.
Bless their little
coming
hearts. If
from
they
Marc.
think,
This
go
coming from
ahead.
Marc Randazza, an alleged expert free speech attorney. Alleged. And he said he hitched his wagons to buddy David Gingras, ostensibly. What is going on here?
But bless his little naive heart if he thinks that Reddit is a notorious cesspool. I have some websites to share with that person that will make Reddit look like the fucking kiddie pool at the beach. Like, come on, really?
Reddit led respondent to describe them as, quote, fucking assholes. Not in court, but in private email.
Oh no! Somebody send him an email. Oh no!
We've read most of this stuff before. This is just a rephrasing of what David sent, and it's roughly the same length. And what became a proceeding Kafka would consider too far-fetched to believe? What the hell? Now we're referencing Kafka. What is going on here? I think the insanity of this has just increased. What is going on, guys? As Bruce might say. The bar charges respondent with 6 different acts of misconduct during Owens. And there they are. I don't want to read them. We've talked about them before. None of these claims have merit. Yet the presiding disciplinary judge disagrees and allowed a partial judgment on them. Okay. What is going on? Oh, let's see. None of these claims have merit. First, claims 1 through 4 arise from free speech and conduct, footnote 1, which is protected by the First Amendment Arizona Constitution's free speech. Footnote 1, reports to law enforcement are protected petitioning activity. Submission of complaints to a police department, with lots of ellipses in the middle of all that, constitutes petitioning activity protected by the petition clause. Not when the attorney knows that there is a valid subpoena issued to a witness. That doesn't hold water. David Gingras cannot claim it was not valid. And as I think, who was the PDJ that made a decision on that already? No, I can't remember. Never mind. This is so infuriating. Claims 5 and 6 are demonstrably factually false. Boy, there's a lot of LY words in there. Are we going to demonstrate factually how they are false, or we're just going to claim such?
Oh, we're just gonna scream it.
The claim.
Yeah.
And prosecuting respondent for claim 6 is a violation to the right to petition. The state bar cannot impose discipline for constitutionally protected speech and conduct absent narrow circumstances which are not present here. I wonder if this might be Marc Randazza's one and only entry into this. We'll see.
It was limited, right? So maybe it's just one,
Let's
ongoing
come in, let's set something on fire and then leave. Set something on fire and leave. That would be that. That's a metaphor. I'm not saying he's actually burning down the state bar, although I think if David Gingras wanted to. Never mind, I'm not encouraging you to do that, nor am I suggesting he should even consider such nonsense. Oh, let's see. Third, even if respondent unintentionally violated a court order, of course it's got to be unintentionally, because the order was so vague and ambiguous, it was impossible to understand. What is impossible to understand? That parties should not disclose medical documents to anyone other than themselves, that being counsel for either side. But yet David Gingras released it publicly on his blog, and I think somewhere else. Seems like there's more than one place.
He's just so prolific on his fucking blog. Like,
I'm disappointed. I'm disappointed so far in the Randazza powerhouse lawyering. I'm disappointed. That aspect of the case must be dismissed because the state bar has arbitrarily refused to discipline opposing counsel in Owens for violating the same order in the same manner as respondent. Greg Woodnick did not post Clayton Eckerd or Laura Owens' medical documentation on his website. What the hell? Oh. Are you engaging in things in chat that you shouldn't be doing? What's going on here?
Don't worry about what I'm doing.
Behave
Fine.
yourself.
Why? It's
I don't
Friday.
know. I told them not to behave last time, so I probably
Well,
shouldn't go there.
then just let me enjoy my friends in chat, okay? It's fine.
Why can't you behave? Oh, why can't you behave? Okay. Name that show.
Okay. I don't think I can right now.
Kiss Me Kate, Cole Porter.
Oh, okay.
Yeah. Which occurred before respondent even appeared in the case. Arizona's anti-slapp law. I love how we're trying to use anti-slapp. This is going to be an entertaining. Arizona's anti-slapp law and the due process clause forbid state actors from arbitrarily enforcing vague laws or orders in this manner. It wasn't vague. So even if the bar's first claim was otherwise factually and legally correct, which it is not, dismissal of the claim is still mandatory. It says him. I'm not going to, I see Sarah saying stuff. I keep deranging people's streams. I'll ignore it. That's okay. Carry on. Derange away. Fourth, the complaint accuses respondent of knowingly presenting false testimony from Owens. That allegation is false, and the bar has no admissible evidence to support it. Actually, I think they did have the evidence. Because we talked about how he knew. Especially when it came to her admitting that she had changed a sonogram and didn't want to share it with their own expert, Dr. Michael Medchill, because Laura Owens admitted to having changed by editing, by committing medical fraud, by putting her name on someone else's sonogram.
To protect her privacy or whatever that bullshit was that we covered on Wednesday about all this, like, I only altered it because I didn't want, like, the clinic to say, like, I was some not fucking, I remember being gobsmacked about that too, but which I shouldn't have been, but, you know.
Jen the Couch Phrase says, just because, what does that say? Gunjarass?
Gunjarass.
Okay, that's a new one. Got caught doesn't mean it's arbitrary. No, it's not arbitrary in the least. But they're going to make that argument because that's all they've got. They don't really have much, really, in my opinion. In short, the bar's theory appears to be Miss Owens offered one version of events before his time. Later, Miss Owens changed her story slightly. No, that wasn't slightly. It was an entirely different location, which also turned out to be false. Yeah. Therefore, respondent must have known the first version was true and the second was false. What?
So
we're claiming that's their theory, and therefore this theory is false. This argument fails for an obvious reason of logic. Just because a witness changes a prior statement does not automatically show the first statement was true and the second statement was false. Oh my God.
Wow, that's some really interesting logic there. Like, that totally negates that she fucking lied and that she forged that sonogram. Oh, but I changed the story, therefore pay no attention to that, what I just did. No. Let's go ahead and, like, just pretend that didn't exist, and now I'm telling the truth, and obviously that's not a thing, blah, blah, blah. Like, that's not what free speech is about. Oh my God. Oh my fucking God.
Oh my God. Yeah. You should Google Marc Randazza and see what you get.
Maybe I will.
Yeah, you should. Because I think it would be just so we're clear about what he specializes in. It is equally possible the witness realized the first statement was inaccurate and corrected it, which is not only proper but mandatory. But she was never pregnant, so it can't be a first statement being inaccurate and getting corrected. None of them were true. None of the statements were true.
But no, don't worry about it. Like, you could still lie and then, I'm going to change my story and now it's all fine.
She had more than one version of events. She had multiple versions of events, and all of them, as found in a court of law, as ruled on by a judge as a matter of law, were found to be false. All of them, including paternity.
Wow.
Which is why Clayton got a ruling in his favor.
Okay, well, this guy kind of does look like a douchebag, but...
In that situation, absent clear and convincing evidence showing the lawyer knew which version was true and which was false, the rules do not permit discipline simply because a witness changed their story. But all of them were false. The bar's theory also ignores the fact the opposing party, Clayton Eckert, did the exact same thing while the case was pending. He changed his version of events in several ways. No, he didn't. No. He's been far more consistent than Laura ever has been. Ever. Oh my God. Yet again, the bar has selectively chosen not. So this feeds into David's butthurtness that why am I being singled out and being oppressed and persecuted? Greg Woodnick did the same thing. No, he didn't. I've watched this whole thing from the beginning. Nothing comparative.
Mm-mm.
So disappointing Marc Randazza's in on this.
I just found some article about him from February of 25 about Trump and the First Amendment. And I'm just, first of all, I'm sorry for I should have trigger warned everybody on using that name. My bad. I
Is
might
there a
have
TLDR?
to, not yet, but Claude is going to give me one. So just please continue and I will burn some GPU cycles.
Okay, interrupt me when Claude is done clodding. We're upset that the bar didn't pursue discipline against Woodnick for the same conduct. Such arbitrary enforcement of the rules violates the Arizona anti-slapp law? This doesn't even make sense, and I'm just an idiot. And the federal due process clause and the state Arizona due process clause. How does their butt hurt over Greg Woodnick not doing what David Gingras did constitute anti-slapp protection? Someone explain this to me like I'm 5, please. My head's hurting.
Claude is clotting. Be right with you.
Okay, that's fine. I've just got to keep going because I'm starting to get a hemorrhage. My brain cells are hemorrhaging stupidity for some reason.
Gee, I wonder why. It's because you're drinking all of this shit. But yeah.
Fifth and finally, the bar's arguments with respect to respondent pursuing a non-meritorious appeal are groundless. The appeal... How are they groundless when both courts said they're not rooted in law or fact? It makes it a non-meritorious appeal when it's obvious that his argument of Rule 26 gives you an escape for anything you could ever do. And the courts say, your argument's not based on law or fact. Two courts decided that. My God. I think this is just being argumentative for the sake of argument, quite honestly.
Well, I mean, that's maybe why he's a good pairing with Gingras, is that he just loves to blather on and argue, and it just delays and kicks shit down the road.
And we're only at the bottom of page 5. Oh, my God.
How many more pages? 40?
48.
40? Holy Christ.
The appeal involved a matter of first impression concerning a new law. What? What new law? Oh my God, this is infuriating. And respondent cited extensive legal authority which showed his argument was not just meritorious, but legally and factually correct. What? I know there were some changes in Rule 26, and Greg Woodnick was involved in the writing of that law. This is outrageous. The Court of Appeals may have disagreed with that position, but it did not find respondents' arguments were frivolous because they were not. But they were not based in fact or law. Oh my God. While a lawyer could and perhaps should be disciplined for bringing a frivolous appeal, that standard is not so low as to encompass non-meritorious appeals. Otherwise, 50% of the appellate lawyers in Arizona must now all face bar charges since someone has to lose and someone has to win. Oh my God. Can I just take my Barbies and go home? Not that I have any Barbies, but...
I wouldn't judge you if you did. I mean, well, maybe a little bit.
Yeah, you would.
Yeah, I would. Yeah, I stand corrected.
Mm-hmm.
Well, okay,
you judge me for far more applicable things.
Probably. But that's the role I play in your life and the role that you play in mine.
Oh! No thanks MK says Marc Randazza has been disciplined in at least 4 states, California, Nevada, Florida, and Massachusetts, and by federal authorities. No thanks. Can you give me a citation or a link on that in the chat? I think you could do that.
Please do.
That might be validating, was what I was going to say.
Well, Claude has done clotting, and I don't pay for the full version of this, but I do have some key points to talk about here.
Teresa
But
S says he's licensed in 5 states. Yeah, I knew that much about him.
he's got quite a few,
Well,
according to his
David's in
website.
2. What does that mean? It's like, okay, you passed the bar in 5 states, so what?
Yeah, well, big fucking deal. Like, but Supreme Court, Massachusetts, Nevada, California, Arizona, Florida, all Massachusetts, Nevada, California, Arizona, Florida federal courts, district courts for the
Oh,
Eastern
EU.
District of Michigan, U.S. District Court for the Northern District of Texas, U.S. District Court for the Northern District of Ohio, 1st, 5th, 6th, 7th, 9th, and 10th Circuit Court of Appeals, and the Court of Appeals for the Federal Circuit.
Wallace says, reading through Randazza's Wikipedia article, he represented Alex Jones? ? I wouldn't be surprised. This is starting to read more like the bull in the china shop type of lawyering, where they just come in, crash around, stir up a lot of mud.
Yeah, and the key takeaways that Claude sort of put together here kind of indicate that. So, and like the kind of the last line, I'll lead with the last line out of this. The Randazza gateway pundit angle is useful because it diffuses this whole. This is just liberal media whining framing. He literally went to bat for a right wing outlet on the same legal theory, all centered around the First Amendment.
Interesting.
Yeah. I mean, I don't know what you want me to do with any of this stuff. Like,
No, unless it says he's MAGA, I don't care.
yeah,
Which I wouldn't be surprised. There's a lot of
how about you?
attorneys.
Well, yes. How about you keep doing that, and I'll see if I can tease that out without running out of tokens.
Okay. Ooh, tokens. How Chuck E. Cheese.
Welcome to the world of AI.
They do it with Chuck E. Cheese tokens?
I think Chuck E. Cheese tokens are far more valuable than the token spend that you would get with this AI bullshit. But hey, I'm going to make them try and figure this shit out, and we can make sense of it later.
Oh, golly. Based on undisputed facts, this case must be resolved as a matter of law. Yeah, of course. Under the anti-slapp law, the bar cannot meet its burden in showing all claims are justified by clearly established law, nor can the bar show it did not act in order to deter, prevent, or retaliate against the moving party's exercise of constitutional rights. Because the bar cannot meet its burden, this action must be dismissed and respondent must be awarded fees pursuant to cost of damage. Boy, that reads more like a money grab to me. Let's just crash around a bit and we're going to demand money. Yikes. Preliminary discussion of ARS 1271. Do I even want to go into this anymore? Arizona, I'm going to start skipping. We're only at page 6. This talks about anti-slapp. This might be entertaining. Maybe I'll keep going. Strategic actions against public participation, known as anti-slapp law. The term slap was originally adopted in California. Okay, this is a little bit historical. Let's skip a little bit. Like California, Arizona's anti-slapp law allows any person to bring a special form of motion in any legal action that involves a person's lawful exercise of the right of petition or right of speech pursuant to U.S. Constitution or Arizona Constitution. The statute defines legal action to include any written investigative demand or compulsory legal process or any regulatory or administrative action by a state actor. When an anti-slapp motion is filed, I don't see how this works. When an anti-slapp motion is filed, a person who files a motion pursuant to subsection A of this section has the burden of establishing prima facie case proof that the legal action was substantially motivated by a desire to deter, retaliate against, or prevent the lawful exercise of a constitutional right. No, the Arizona bar is preserving their rights to regulate a professional conduct. These are the terms which you agree to be a practicing and member in good standing with the Bar of Arizona. They can self-regulate.
Yes, that's their prerogative. So the TLDR, like of the TLDRs here, is this guy pro-mega? Not necessarily. He's a First Amendment absolutist. And I know that there's a lot of blurred lines between those things. So, but if he thinks that like this whole Alex Jones thing is like, yeah, he can go say whatever he wants and not have to face consequences of that. Well, I mean, that's kind of pro MAGA in a lot of ways are pro crazy, because that's clearly a crazy line, to cross. But I don't know.
Bruce the Moose says, if this Randazzo guy stopped David Gingras from calling more people total assholes in these filings, then he's worth the money. Yeah, maybe. What I wonder would be what Mr. Randazza's position on speech that threatens to unalive people. Is that it's free speech. You can say anything you want. Is that his position? You could make explicit threats. I wonder what his position would be. I don't know. I have no answer to that. I'm just throwing out a hypothetical. When an anti-slapp motion is filed, a person who files a motion pursuant to that, I just read that, blah, 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 blah. If the showing is made, the court is required to dismiss the action unless the responding party shows that the legal action on which the motion is based is justified by clearly established law, and the responding party did not act according to deter, prevent, retaliate moving parties exercise constitutional rights. It's not an anti-slapp situation, in my opinion. Not at all. I mean, when you... oh, golly, I can't even explain that anymore. I'm done. Since Arizona anti-slapp was amended in 2022, there have been no published decisions applying it in state bar cases. We want this to go to another trial, don't we? However, other states with similar laws agree that such laws apply in discipline cases. Really? Texas, holding the Texas Citizen Participation Act, applies commission's disciplinary proceeding against an attorney, finding the commission met its burden of showing its claims did not violate TCPA, enacted to safeguard the constitutional rights to petition, speak for the associate, blah, blah, blah. Okay, blah, blah, blah. Assuming without deciding that the anti-slapp statute applies to bar cases, but finding the law was not violated under the facts of the case. This is starting to get too thick for my interest. This case involves a regulatory or administrative action by a state actor. Is he a state actor? And the case plainly arises from respondent's speech. Not just his speech, also conduct, and petitioning activity under the First Amendment and Arizona Constitution. In addition, the bar's claims plainly seek to punish respondent for his speech and conduct. Well, there we go. See, I just said conduct. Thereby deterring and retaliating against the exercise of protected rights. No.
Yeah, go ahead.
Unless we disassemble the entire purpose of the American bar or the state bars, unless we entirely dismantle their ability to regulate the professional organization, this is all bullshit, in my opinion.
Well, and that's kind of what these types sort of do. That's kind of their MO, to try and just shake all that apart so anybody can say anything and not suffer any sort of consequence about that, even if they are violating the rules of something as, I don't know, to my poor little common man brain, simple as don't post your client's fucking records on your blog because the judge said no, don't do that. But hey, say whatever you want, don't suffer any consequences.
That's wild.
And an additional sort of filtering through other things here, it's this dude seems to be willing to represent just highly toxic, far right-wing figure type clients and people, because he's just he's probably more libertarian. I would say he's probably more libertarian than he is MAGA, although he runs in those circles because it's super adjacent to that. And so it's no wonder he's willing to take on somebody like David the dipshit Gingras, because he's whoa, somebody's going to take on the First Amendment, and they kind of clump themselves together to, form a little First Amendment wank fest that they can, do all this stuff with. I don't know. Just
good night to Deb Peterson.
Good night, Deb. Thanks for joining.
Night. Sleep tight. I'm going to keep going. I'm going to skip through because I'm getting annoyed. See, the court must dismiss the case because they haven't justified by clearly established law, blah, 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 blah. Argument. And then we go through a bunch of Owens stuff, just like we had, and then we reference the request for judicial notice. A lot of back and forth, so we can
Back
skip
for more,
a lot
blah,
of this.
blah,
Is
blah.
Owens v. Ecker. Let's see. Based on the above fact, the bar claims respondent violated multiple rules. Nothing in the February 21 order required to seal. Okay, first, the order says nothing about sealing anything, nor does it contain the words "it is ordered." Oh, now we're going to argue semantics. Language used is "let the record reflect," which is materially different than other parts "it is ordered." This text appears to simply reflect an informal off-the-record agreement reached between counsel at a hearing. Respondent was not present and which took place more than a month before. He is responsible for the entirety of the case he takes on. It's just that simple.
Where did this? Where did you get this document? This particular one. Where's
This comes
at?
from Victims of Laura Owens. Do you want me to send you a link in the
Would
private
you send
chat?
me a link in the background, and I will
Where's the
feed
damn
this
private chat? There it is.
I'll
Put it in the
feed
private
this
chat.
through the GPTs and see what I
For
can.
the studio.
Yes.
Yeah, would you please? I'm
Yep.
getting irritated by this.
I
thing.
know this is getting this. That didn't do a goddamn thing. I need the actual link to the document.
That is the link to the document. Oh, is it not? Oh,
No.
what happened? Oh, hang on. I think my let me try this. It's not giving me the whole thing. Why is it not giving me the whole thing?
Send it in the other chat form.
Which other chat form?
The one that starts with T.
Let's start. Oh. Yeah, I don't know why it's not. Oh, it's chopping off half the link for some reason. I don't know if that's going to work.
Oh, let's find out.
I don't know why it's amending.
Yes.
Yeah. Okay.
That
All
worked.
right. Good.
Yep. Okay.
Well, until then, I'll just keep skimming.
Yeah, skim and do whatever. I'm gonna see what I can. Yeah.
Because this is so annoying. Wallace says, "Don't feed the AI monster." Oh no!
Oh, Wallace, don't you know me? I love burning up those GPT cycles. Let's go. Let's burn down and boil an ocean. It's fine.
He likes the smell of burning silicon in the morning.
Yeah, kind of.
Second, Miss Owens made multiple requests, sealing for confidentiality. Yeah, because she wanted the whole case behind closed doors, not just documents. This is absurd. Third, Mr. Woodick successfully argued it would be unlawful prior restraint on... Okay, we've heard this stuff. As I spy on more of this document. The language in question contained no time limits, blah, 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 blah. Even if... Oh, God, now we're making some insults here. Merely stating no party shall disclose outside of themselves medical record, blah, blah, seems to mean that if any party exchanged any document with the other party, that document could not be disclosed to anyone, not even the court. What? If that is not what it means, then what does it mean? No party shall disclose outside of themselves any medical or other... Oh my God. I know what it means. A person of even high intelligence cannot tell, but yet I can understand it. What is going on here? Such a vague, ambiguous order is facially unconstitutional. What? What? He must have boiled an entire 5-gallon pot of spaghetti to start throwing at the wall.
God, no kidding.
Fifth, the bar's position ignores the requirements of Family Rule Law 17. Family Law Rule... Oh, God, whatever. Sealing, redacting, unsealing court records. This wasn't a sealed court record. Oh, Jesus. Maybe I should go into law. Maybe that should be my next career. I mean, I don't like wearing suits all the time, but Jesus Christ.
Yeah, you should be used to doing that from your previous life.
Oh, that's why I hate it. That's
I know, but...
That's exactly why I never want to wear one. That pushed me away from a dress-up profession, was the whole thing. I had 2 suits on my mission, too. Sort of a super dark green one and a slightly steel blue dark one. I look pretty good in them. I was much.
I don't mind
skinnier.
dressing up occasionally and looking a little snazzy, but like I couldn't do it for a, couldn't do it for a profession day to day, but for a special occasion, I wouldn't mind.
But the rule contains multiple mandatory prerequisites, findings of fact and conclusions, blah, 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 blah. 6, Mr. Woodnick interpreted the ambiguous order exactly the same way respondent did. No, he didn't. Oh, my God. Okay, I can't. This leads to the 7th and final problem. Even if the bar's interpretation of the order was factual and legally correct, which it clearly is not, the anti-slapp law and the due process clause prohibit the bar from arbitrarily choosing to punish David Gingras while ignoring identical misconduct by Mr. Woodnick.
Oh,
but they did it.
Right.
They did the same thing.
They did.
never
Oh my God. It's not like I killed somebody. Yeah.
David's brain is smoother than a porn star's butthole.
That's what I'm going with.
As well you should.
Specifically to prove the bar's conduct was not intended to unlawfully deter blah, 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 blah. Against respondent, the bar must show a consistent practice of pursuing similar legal actions against similarly situated persons who did not lawfully exercise constitutional rights.
So, okay, Claude got this down to 6 concise points and a through line. ChatGPT is still burning through a forest, but
is it not done yet?
ChatGPT is not. I've sent it after both of them because I want to see like how they
Just
both sort of do their thing. But
can you have them talk to each other and argue it out if they're both saying the same thing?
I feel like that might activate Skynet. So no, I'm not going to do that.
Let's see. Wallace Juno is asking where I went on my mission. Let me think about that. Do I want to reveal that or not? Nowhere special, where Eskimos live. I think I'll just give a clue. Although,
yeah,
not outer Mongolia.
That's so a clue. Yeah, okay, that was totally discreet. Good job.
Well, I do drop breadcrumbs for my future doctors on occasion.
It is. I mean, it is the biggest state in the entire country. But
Carol Key, good to see you. You're not late. You're perfectly on time for this nonsense. Marc Randazza, famed First Amendment free speech attorney to the stars, has entered the chat for David Gingras' bar complaint. That's what you have, not really missed. I'm only 16 pages in, 48 pages. And I'm not trying to make it.
Well, okay, so I can try and save you.
Justice for Lauren's mom. Justice for Lauren's mom.
David's brain is smoother than a porn star's butthole.
Oh my good God. I'm suffering because we're 2 hours in and I need to end this nonsense.
Okay. And I know that you want to torture me with whatever Gingras had, for the other commentaries. So I'm just going to breeze through.
You want to go through the highlights with your GPT?
Yeah, I'm just going to go. Yeah, let's just see what this kind of comes up with. Okay. Yeah. That one. I think I just broke OpenAI. Okay. Just for the record, it errored out. So fuck that place. All right. The meta story here is perfect. Randazza is now representing dipshit facing bar discipline, and the theory he's deploying is the exact same First Amendment framework he wrote about in the AP Gulf of America or Gulf of Mexico article that I referenced or teased about earlier. It recapped the case into one paragraph instead of how many pages? 12, 15, 17, 40, something. So it says the 6 charges and Randazza's responses in plain English are the following. 1, violated a sealing order. Randazza says that there was no actual sealing order. The language used was, quote, let the record reflect, not it is ordered. He also points out that opposing counsel did the exact same thing and he didn't get charged. We just went through that. Okay. Number 2, asked police to enforce a restraining order. He says calling the police to enforce a valid California domestic violence restraining order is constitutionally protected petition activity. The bar literally wants to discipline a lawyer for calling the cops on a DVRO violation. Number 3, called Reddit trolls fucking assholes in a private email. Gingras sent this on his own behalf, not as a lawyer. Randazza cites a pile of case law establishing that profanity in private communications is protected speech. Again, please keep in mind, to our dear listeners, this is what Randazza is suggesting. This is not the facts. Okay, this is the summary of this ridiculous document. Number 4, disparaging comments about the judge. The PDJ already ruled against Gingras on this one. Randazza is preserving it for appeal, arguing truth is an absolute defense and you can't discipline a lawyer for true statements about judicial conduct. Number 5, presenting false testimony. The bar's theory is that Owens changed her story. Therefore, Gingras must have known which version was false. Randazza calls this logically incoherent and notes Eckerd's side changed their story too, with no bar complaint filed. Number 6, filing a non-meritorious appeal. Randazza's response is basically, if losing an appeal is a disciplinary offense, half of Arizona's appellate bar is now at risk of disbarment.
Yeah, we already touched on that one.
Yeah. So the through line connecting this to, and I'm reading the rest of this here. The through line connecting this to your earlier conversation, this is a textbook example of the same argument Randazza made about the AP situation with the Gulf of Mexico, Gulf of America, whatever. The government, here, the state bar, cannot use vague standards to selectively punish people for speech and conduct it dislikes, while ignoring identical behavior from those on the approved, quote, approved side. This selective enforcement argument runs through almost every single count. This and as it says, as a spicy bonus detail, the motion is signed by Randazza himself, filed just 3 days ago. So this is live, active litigation. So there it is. That is Claude's interpretation of the thing, and it's like, yes, but if that's what it takes to save all of your like brain cells from going through the rest of all of this nonsense.
Yeah, I think I'm kind of overreading it.
Yeah. Probably.
Caro says, oh no, I Googled him before. He's a hoot. LOL, he's just as damaged as Gingras. What a headache, she says. Yeah, Thank you, gentlemen, for tolerating this topic subject on a Friday evening. Well, I was hoping it would be a little bit more creative than just sort of re-vomiting what David already wrote. This is just a rehashing of what he's already done. I know about the same length.
Not terribly interesting, honestly.
I'm only at page 25 in my skimming after you reading that little summary. And it goes through Mike Maricini and David trying to get him arrested because David thinks that unless he gets his way, that California restraining orders apply more than subpoenas. Respondent never prevented Maricini. I'm just going to keep going. This is just crazy.
I feel like you can probably just, skip a lot of this shit.
If a lawyer uses profanity or expletives in court for the purpose of displaying contempt towards a judge, a witness, or anyone else, that would be a different situation. I'm just reading highlights, it seems. But no law supports the bar position here that a lawyer who's not engaged in the practice of law is forbidden from using otherwise constitutionally protected expletives. It's not just about expletives. This is just such selective arguing. It's ridiculous. Absolutely ridiculous. We do not, Caro, know if he's representing Gingras pro bono, at least not yet. If there is, I think he's already asked for fees if they win. So I hope he's charging David. I hope he's not that stupid. But what do I know? If anyone of any ability, any substantive ability, were to get involved in anything with Owens v. Eckerd and Dingus, I would hope they're charging their full rate.
I would hope so.
But apparently, at least according to some people in chat, that it's not like Mr. Randazza has a glowing reputation by the sound of it.
Sounds like he's a really avid and aggressive First Amendment lawyer. And that's the crux of all of this, and probably why Gingras looked him up and maybe tried to retain him is like he doesn't give a fuck who he represents or how smarmy they are, like the Alex Joneses of the world or
Oh, what's this?
any of that. Like, it's just he don't give a fuck.
Marc Randazza was suspended from the practice of trademark and other non-patent law before the United States Patent and Trademark Office. Ooh, 2018. I'm just Googling. So he's been slapped a little bit. Interesting. I'm not surprised. Because who else would David affiliate with?
Oh, well, birds of a feather.
Yeah, squawk together.
Blather on for 48 pages together.
The disposition of this claim is easy to resolve because the bar has no evidence of any kind to support the alleged misconduct. So this is so because August 25 Supreme Court issued an order amending comment 8 to ER 33 to clarify standards that govern the presentation of false evidence. That comment explains in detail what a lawyer can and cannot do when faced with the possibility that a client has not been truthful. Full comment 8 to ER 33 states prohibition of false evidence only applies if the lawyer knows that the evidence is false. She told him she changed a sonogram. He knew. And not to share that with their expert, Michael Medchill. We saw that. We talked about that, a few nights ago. Oh, God, this is just such weak sauce. I'm so disappointed.
Hey, K-Dubs, $5. Thank you.
Oh, read it.
Hey,
Sorry,
can anyone tell me how to delete a Discord account? And for $5, I can absolutely tell you how to delete a Discord account.
Thanks, K-Dubs, for the 5.
Thank you for the 5. I'm going to just toss that link in the chat for you because that is how you...
Wow, you're quick like a bunny. Quick like a bunny on that one.
But don't let that get out to my dating pool.
What? Quick like a bunny?
That I'm quick, because I'm not.
Well, your fingers may be quick, but never mind. Okay, let's see. Complaints.
Never mind. Yeah.
Okay. I'm just going to keep moving before I get myself into trouble. Wait.
I plead the fifth. I'm not going to get myself criminally in trouble. I plead the fifth.
Someone's changed her. Okay, changing testimony. God, page 32. Does not appear Arizona Supreme Court has established any authority regarding the correct standards under which a lawyer's knowledge of falsity may be inferred, but clearly the answer cannot be based on nothing but pure speculation. Oh God, this man is insufferable too. Idaho State Bar, blah, 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 blah. Because Ms. Owens gave contradictory versions of events, the bar argues the respondent was required to withdraw. See, but this is both misstatement of law and ignores fact. Mr. Eckert also offered contradictory versions of events. Mr. Eckert filed a petition for harassment injunction against Ms. Owens and his original by over 100 emails. Later, Mr. Woodnick presented a materially different story to the motion in his court rule. Respondent obtained injunction harassment and petition received 500. God. Really? We're going to squibble about that?
No, this dude's a First Amendment maximalist, of course. Like, he attracts and goes after the, like, he attracts the trash can fire clients, right? Like, that's just the fucking floating ones on the river that are just on fire. Like, that's just how he fucking is. That's this type of guy.
The turds at the top of the pool.
And they doth float.
Pursuing an unsuccessful appeal, response, blah, 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 blah. Extensive legal authority. They kicked... I can't. Oh, look, anti-slapp.
Shall we just park this and then move on to like the thing,
Let me get to the bottom.
Keep scrolling. We can find.
Let me get to the bottom.
Just keep falling. Yeah, goddamn.
This is too much. Okay, let's get to here's the conclusion. For the reasons stated above and all this bloviating and pontificating for 48 pages, this court must dismiss the amended complaint in its entirety pursuant to ARS, etc. In the alternative, the court must grant summary judgment in favor of David Gingras as to all claims. I don't think they're going to get their wish.
Yeah.
April 14, 2026, and sent to everybody. Okay, God almighty, switch.
Do you feel better now that you've gone through
Oh
that?
my
Or
goodness. You know,
I tried so
closing
many
that
times.
tab.
I tried so many times to save you from this with
I was
my AIs, and like you just, I have to. I go.
I was
I have
hoping
to
it
get
would
to
get
the
at
end. Oh
least
my
interesting.
god!
I was
No,
hoping
it's
it would
not.
get
Wasn't
interesting. It
based
just
like
gets worse.
no.
Okay, so this comes from the Twitters of Seeking Justice for All Victims of Laura Owens at Clayton's Justice.
Look, chat. One of these days, he's going to actually listen to me when I say that I can save him this pain. But until then, he's going to continue to torture himself, and
Ooh, chat's getting snarky now. I love it.
that's
I'm not going to
fine.
read. I'm not going to read that out loud though. I don't
Yes.
want to.
See you next Tuesday.
Yeah, there
That's
we go.
exactly right. Yep. Yeah, I got a lot of those types of terms, but I'm going to reserve them because
We're monetized now. We have to clean up our act.
well,
We don't want to get demonetized.
you do. I don't have to do shit because. Oh,
Okay,
wait a minute.
fine.
Now I don't want to do shit.
So this comes from Twitter, Clayton's Justice. Just when we think soon to be disbarred at David S. Gingras can't possibly sink any lower. We hope he gets disbarred, I think. I mean, I sort of hope he gets disbarred.
I mean, same.
But apparently Clayton's Justice does too. Okay. He manages to prove us wrong. Tonight he put out a blog and video where he mused about the gay vibes of Clayton Echard, sang about Greg Woodnick and Clayton Echard touching each other, and referred to Maricopa County Attorney Rachel Mitchell as cishet, being shorthand for cisgender hetero. For those of you who don't know,
heterosexual.
once again, he gleefully bragged about how his liar and con artist client, Laura Michelle Owens, will never pay Clayton Echard the $200,000 more plus. She owes him. I'm editorializing just a little bit, sorry. But he's such a nice guy, folks. Actions speak louder than words, David, and your actions scream you are a malignant narcissist seething with jealousy over people like Greg Woodnick, the tilted lawyer, and Rachel Juarez, people with successful and thriving legal careers, loving and supportive families who have not torched their personal lives and careers over a lying pregnancy scammer. This is saucy. This is great.
Yeah.
Then, of course, we get a diatribe about how the PDJ and Jim Lee do not believe in the First Amendment because Gingras cannot spout whatever derogatory language he wants as a licensed attorney of the state of Arizona. As a licensed attorney of the Arizona State Bar. God, these multifocal lenses, I swear. Even after all these years of practicing law, it is remarkable that David cannot grasp that he is bound by the ethical and professional standards of the bar as an attorney. If you want to be an asshole and insult everyone you disagree with, David, step down from the bar and knock yourself out. We look forward to your disbarment or suspension from the Arizona State Bar. And then at the bottom, which is becoming a reoccurring theme on this Twitter, maybe one day you will admit you have serious problems, and they've got a link to aa.org. That's Alcoholics Anonymous.
I mean, I have my fair share of problems with AA, but yeah.
It gets a little
being...
It's a little Jesus culty for my taste.
Yes, same. Any of those like blank A's, AA, NA, whatever, OA.
But Jody Who says, "Well, damn, I really like Marc Randazza. I'm surprised he got involved in this shit show." I'm slightly surprised. I sort of have to walk back that I said, no, Mark's not going to appear just for David, but here he is. He's done it. So I stand corrected that David didn't get Mark to enter into the fray with this nonsense. So that's a correction I have to make.
Jody, I hear what you're saying. I think that like in some respects, I want to like his ethos around like people should be able to say what they want and not get not get punished about that. But this guy has also got a really, really interesting and, perhaps tainted history of the types of clients that he takes on when it's like blatantly dangerous to go on some sort of public or publicly accessible sort of space and lay the claims, whether they're as egregious as like Alex Jones in the Sandy Hook situation or some of the stuff out of the White House with the AP and like this, like, it's just, you can't, I don't think it is a righteous endeavor to pursue this absolutist First Amendment with no consequence scenario, and then turn around and defend people. To everybody deserves a good defense. Don't get me wrong, but like this, his mo here seems to be like this extreme position where even if you're doing damage to others and denying shit like Sandy Hook was a fucking conspiracy and, you know, government setup or whatever, and go and like put up a wall around that. Like, I feel like that's just like, that is, you can't, you just that's not, that crosses a line, in my opinion. Freedom of expression and freedom of speech is not freedom from consequence. You cannot be in a crowded room or a crowded stadium, scream fire or scream emergency or something like that, and then go on and you just can't. You just simply can't do that. It's not legal. It's not ethical. It's not any of that stuff. So, yeah, fuck that guy. And if he's going to go and he's going to do this defense of Gingras for doing and saying things like he's done, like look at all of the shit that he's posted on his blog to date, the stuff that I've put through the GPTs, and even all the nonsense that I've gone like and that we've read, been touched on briefly since the last analysis I did with all the language analysis and summaries and everything. Gingras is still up to his bullshit. He should not have been posting that stuff to his blog about the medical information. It was very, very clear. Don't post that shit, and he did it anyway, under this guise of being the First Amendment. Fuck that. That's not okay. If he wasn't the representative, or if he wasn't involved in this sort of thing, it might be a different story. But that's not the case here, in my opinion, in my observation. So he is culpable. He broke the rules. He did what he wasn't supposed to do, and he deserves to have what's coming to him and the discipline accordingly. Just as if I did that shit at my job, if I was told not to do something and I went and posted about it on Twitter or on Blue Sky or something like that, and I did it, and if somebody went and, like, you know, from my work and was like, hey, you shouldn't have done that because we told you not to post that publicly. What, am I going to sit here and claim it's my First Amendment right to talk about that? Really? Really? No, that wouldn't fly. And neither does this. Again, in my opinion. Thank you for focusing me on that, you ass.
And for those of you playing bingo, you may now check off Jeep Daddy Rants in your bingo card. Ta-da!
This is simple. This isn't complicated. My God.
That's why I thought I'd give you the highlight.
I know.
Jim,
I know exactly why you did it. I know exactly why you did it. But
exactly.
You're also
Well, it's like, oh, there's a rant coming on. Let him have
go fuck yourself. Yeah. Anyway, please.
Let him have the floor. Give him the full stage for an epic rant.
And you needed a breather anyway because you were blowing your nose or something on the off.
Yes, I was.
Stage.
Then the Couch Fry says the only way we know where the limits of free speech are is to test them. Sure, but I would say if you're going to grab the high voltage wires, be prepared for a shock.
This shouldn't
be my response.
But this isn't a test of that. There was a really clear direction to not do something, and he fucking did it. Allegedly.
Some things are common sense.
I just this blows my mind. This blows my fucking mind that this is like even up for question.
Yeah.
But again, this is why I drink, and this is like, I can't make sense of all of this shit.
Wallace says, standing ovation for tonight's rant for you.
God. Well, thank you.
Get him, Jeep Poppy.
Let's go, bitch. Let's go. Let's go. I'm sitting there. If those court proceedings are open for public opinion, I've got a script ready to go.
Oh my gosh.
And a flask.
Oh my gosh.
Oh,
and
wait.
a flask. All right, let's we'll let's go to the more fun stuff and then call it a night, because we're dribbling over 2.5 hours already.
God. It's like
from the blogs of Douche Canoe Esquire. This is on the archive page. So it has been archived today. And this is the blog entitled, What's an Anti-Slapp Motion under ARS 1271? And we'll get to the juicy stuff. And I've even got something else pulled up for just a sampling little video. We'll see. We'll test the waters if it becomes fair use or if someone gets nasty. Yeah, he wants people to share his opinions and his views. But if he comes after me with a fair use thing, it's like, okay, no more for you. No more.
Oh, you've used it too much.
You've
used it in a way that's not what I want you to use it for.
Judge, I want you to silence
Jesus
them.
Christ.
I want you to silence all of my opposition.
Christ.
That's my free speech. I want everybody silenced but me.
Speaking of, put a dildo up your ass and just shut the fuck up. God damn it.
Some people could use that, I think.
Yes, they could.
I can't. That would be bad news.
Well,
bad news. Yeah. And this is dated today, right? Yeah, today, April 17. Bar fight 2026. Okay.
There's a little bit left of today here, so yeah.
So Dingus the Douche Canoe says,
the fucking Douche Canoe.
This is probably way too much technical for way too much. Well, that works. Way too technical for most people. But below is a video talking about Arizona's anti-slapp law and the motion to dismiss I just filed. I thought Randazza filed it. Or am I? Never mind. Never mind. Maybe I'm confusing things at the end of this nonsense. It's an important law that is not well understood, so I just want to shed some light on why it matters so much. He doesn't seem to understand even well understood laws, does he? Like Rule 26. Even from stupid people like me who don't practice in law seem to understand it better. Yikes. Also, fun fact. As I was writing this, Randazza literally texted me to say that our good friend and completely 100% cishet DA Rachel Mitchell just lost an attempt to strike down the anti-slapp law. And it goes to an AZ Central story. It's not all that interesting. I didn't read it, but I just kind of popped it up and went, not worth bringing up. So what? I mean, she's not going to win everything either. Who cares? Bruce is here. Bruce says he certainly does seem to be filing things, blogging, and making videos. The problem is none of them are very convincing to me. Fair, Bruce.
Funny that, huh?
And then David says, oops. And the judge's decision contains many, many good quotes that I can use later with an under advisement ruling. One of the best aspects of the ruling was this. Rachel Mitchell tried to argue the Arizona anti-slapp law violated the Supreme Court's exclusive authority to create rules of procedure. She also said she said only the Arizona Supreme Court can create procedural rules, which is true. He agrees with that? I mean, I'm fascinated now. Thus, she argued the anti-slapp law didn't apply in criminal cases because the Arizona Supreme Court has never adopted it as part of the criminal procedure rules. This is technically a separation of powers argument. I don't know. I didn't look it up yet, so I can't take a position on what he's claiming here. He may be accurate. He may not be accurate. He tends not to be accurate in many of his assertions on his blog postings, so I would have to review what he's blathering on about to have any qualified opinion, which I'd prefer to have, so I'm not going to qualify myself on that. This has not come up in my bar case yet, but Jim Lee will probably try to make the same argument, that the bar cases fall under the Arizona Supreme Court's exclusive duty to regulate the practice of law, and therefore the Arizona anti-slapp law, which is not mentioned in the Supreme Court procedural rules for discipline cases, does not apply to me. The trial judge just slapped that argument right out of Rachel Mitchell's mouth. Oh, see, now he's getting physically violent again.
Oh dear.
Why does it have to be slapped out of her mouth? Oh, Jesus. Is he abusive? Do we know?
You think?
Well, actually, I think we kind of do. If there's any veracity to his old criminal case that unfortunately didn't get adjudicated, I think the answer might be yes. But that's just my opinion. I think he might be abusive. Let's see. The legislature may abrogate blah blah blah. I don't want to read that crap. I don't want to read this. This is 10,000% correct. Oh, Jesus. The anti-slapp law creates a remedy for victims of illegal state action. The bar regulating its members is not illegal state action. Otherwise, why have a bar at all? Anyone can practice law and say whatever and do whatever the hell they want and pretend they're attorneys. Please.
Fine.
It's like just
Jeep Daddy Esquire. I'm going to change my fucking title right now. Right the fuck now.
If that's the case, then neither can the health boards regulate licenses for health practitioners in healthcare. By the same logic he's offering here. That means anybody can be a doctor. I would love that. I could retire much quicker that way. That'd be fantastic.
Those rates, goddamn right. Fuck.
Does not change the rules of procedure for bar discipline cases if it simply so says that if a state actor like Jim Lee breaks the what if a state actor like David Gingras breaks the law?
Right.
I have the right to get the case tossed, and Jim Lee must pay me for the damage he has caused. What damage? He hasn't been disbarred. He's not even suspended. What damage?
Yeah, what's your actual harm right now other than you just like the reputational the trolls. Oh, the trolls on Reddit. Oh my god, the trolls on Reddit.
For example, he litigated Jesus. He litigated the case.
Who's the one drinking tonight? Come on.
I know. My head hurts that much already.
This is brain damaged you to some degree. I feel like I need an intervention.
My annoyance of just the sheer stupidity of people who are supposedly licensed professionals who went to school for several years to get a Juris Doctorate, passed bar exams, et cetera, are this stupid and idiotic, in my opinion. It hurts my head. I evidently in my many years, my many decades of life, I set my bar way too low. I should have gone and been a lawyer or a doctor, or at least a lawyer, because apparently the bar is so damn low, they hand them out like jelly beans, and any idiot can practice law and claim anything under free speech. Ugh. Jesus. It's an insult to the legitimate practitioners of law and the legal profession.
This is the very thing that makes people, when they say like lawyers are like pawn scum, blah, 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 like right there with politicians and used car salespeople or any car salespeople, like let's be real, any car salespeople, because they're pieces of shit too. But this is right there with that class of people of just like, this is why lawyers have such a bad fucking reputation.
Yeah. And all of his sanctimonious preaching of, I'm just trying to protect free speech in the First Amendment. Bull fucking shit.
What? No. Lie. Fake fucking news. Fake news.
We want qualified speech that he can manipulate and use to whatever purpose he sees best fit for that moment.
And I agree with what. Speech. Look, and I agree with what Jen said in chat.
What?
It's attempting to engage in witness tampering, because this is they don't have, in my opinion, they don't have ground to stand on from the facts that are represented there. So the only thing that they can do is poison the jury pool and poison and fuck with the witnesses and like make them doubt more and more and more. That's all they have. It's the same reason why. I'm sorry, I'm going to get on like a little political thing here, but you don't have to focus me. Please don't focus me. But it is. This is the same reason why for voting and stuff in this country that they're manipulating and making it more difficult for people, particularly in the Democrat side and in the people of historically marginalized communities side, making it more difficult to vote because they know they can't win. If everybody had access to actually vote with ease, there's a certain contingent in this country that would lose, and they would lose badly. So the only way that they can do that is to cheat. And this is the exact same fucking thing that they're doing in this case. The exact same fucking thing. They're poisoning the potential jury pool, and they're poisoning witnesses, and they're casting doubt, and they're trying to do it in the court of public opinion. And it's only by the righteous work of the people who are actually talking about this and making sure that it is brought up and talked about and that bullshit is called out that I hope that this is actually not going to be the case. That they'll actually still be able to have some facts here. Rant over.
End rant. Oh my goodness. Oh, continuing on. Now as for my anti-slapp stuff. These pleadings have already been shared, but I'll add them for efficiency, and he does so there. Coming soon. Links TBD. PDJ order finding respondent has failed to make a prima facie case showing that case involves lawful exercise of rights. And maybe later, State Bar's response. State Bar's controverting statement of facts. PDJ's order denying motion to dismiss and return it. And here's my video explainer, which I posted to Rumble, but that's just a test. Let's see, what is this stuff? State of Arizona versus Joy Kurt. I don't know what that is. Under advisement. Oh, this is the thing you talked about earlier. Okay. Now, do I dare share just a snippet of this? Do I dare?
Do it. Do it. Just do it. Live on the edge, Echoes. Live on the edge.
Just a little bit. We'll see what happens. We'll see if I get struck down or not.
Let's just keep us up here in the side, and we're going to react, and like we're going to talk.
I've already fast forwarded in like 4 minutes because he's always playing copyrighted music at the beginning.
Is it really that small though?
I could try and.
And I'm not. I'm talking about the video and not Gingras, because ew.
Well, as you can tell, there's two of him on screen. He hasn't figured out how to make videos yet. He does this weird built-in camera desktop thing and is moving stuff around his desktop, and it's funny to see what he's got on his desktop.
Okay. What is so telling right now? What's
telling is that Clayton's a hottie.
Well, yes, but I'm hyper focused a little bit in the dipshit's video frame on the left, and it's on the left side of like the political sign that's sitting there.
I know, and he's hung a flag. That's new in the last couple days. Yeah, he still has a Trump Pence sign, and he's got a Trump mug. Megan Fox made the joke that David Gingras has more Trump merchandise than she does. And she voted for Trump at one point. I don't think she did more recently, but I'm not sure. And she's interviewed Donald Trump for the news and some other things. But David Gingras still hangs on to this stuff, and he claims whenever he talks about it, it's sarcasm. I'm going, I don't believe you.
Yeah, okay, yeah, it's sarcastic. Okay, yeah, all right.
I don't believe him. Jen the Couchphrase says he's not Maggie, he's trolling, but I'm not sure I buy that.
I think
he did vote at least once for Donald Trump, because why would you buy all this stuff? I mean, most people with principles would say, I'm not that type. I'm not even going to get it.
No, that's like...
I just don't believe him.
The caricature, like, I have my fair share of issues with folks like Stephen Colbert, but like the Colbert Report was a character, and the Late Show with Stephen Colbert is not that. The caricature of that hyper-conservative type with the Colbert Report was strategic, especially compared to like following immediately from the Daily Show, which was definitely left leaning in that respect. That's trolling. That's a caricature. I just don't like, given that he's being represented by this First Amendment absolutist type that and has gone down this like wickedly weird crazy path. I just don't know if I agree with the idea that he's trolling. I don't get it.
I wonder who's going to make it to Sovereign Citizenville first, him or Laura Owens.
Oh, that's a place your bets, folks. Right here, right now.
There have been a few things I've seen more recently where I'm going, who's going to make it there first? The laws, only the laws I like apply to me. Is the sovereign citizen argument in the end.
Yes. And I mean, okay.
His DUI case could push him that way. I'm traveling in my conveyance, officer. I don't need to present my license to you.
Yeah. It's like, okay, Jen, I don't necessarily disagree on principle, but like I think it's gotten to a point with him where he's trolled so far over the Rubicon that he's actually like now in that state of like believing what it is that he's saying, that it's not a troll anymore.
I wonder. It's
so hard to understand like why he would go through these lengths and why he would go through all of these steps to fawn over Laura and fawn over all of these egregious acts against him with this case and all of this stuff. Why would you go through that if it's just a fucking troll? Like,
yeah, I don't know.
Trolls are just there to be chaos monkeys.
Yeah,
it's plastic. It's structural. Like that's the same. Like it's in my world. That's script kiddies who go and just like, tee hee hee. I'm going to try and run a script that I found on the internet to go like do a thing and try and hack an Xbox or hack a PlayStation or whatever. Like, no, you're not a real hacker. Fuck you. You basically haven't left your parents' basement in like, 6 months and you're living off of like Mountain Dew and fucking Doritos.
Hey, don't
Shut
be
the fuck
bashing
up.
Doritos.
I will. They're terrible.
Oh, Cool Ranch Doritos. I'm okay with those.
I was thinking nacho cheese, but
I won't turn down Cool Ranch or nacho. I'm okay. I don't care for the spicy ones, but I'll take the regular ones any day. And I like to crush them up in the bag and just kind of dump it into my mouth.
Oh, okay. Well,
yeah, I'm weird that way.
I just suddenly I have a picture of you like laying on your couch or laying in bed like with this bag of like crumbs of like Doritos and just like pouring it into your mouth on a Friday or Saturday night, going like, "I live my life."
Doritos, like the Cookie Monster, but with Doritos. Cookie Monster, but with Doritos. Maybe.
Yeah. Oh my God.
As opposed to all the Cheetos people with orangey fingers eating their Cheetos,
or they put it on their Cheeto face.
Oh God. I like cheese puffs, but I'm not a Cheetos fan. I like the fluffier ones.
I used to eat them
a little bit of
day,
this.
But, yeah, let's go.
A little bit of this. I don't necessarily want to play the whole thing unless it's super interesting because I don't want to tempt him too much.
Well, let's just see what happens.
Let's see what we get here.
So I sent this little video back, and excuse, I don't sing, I have no voice, but this is
maybe I should not play it at high speed, huh?
You do you.
I was trying to listen to a little more of it before I started the show, but I didn't get very far.
What I sent back.
There's no way out. Clayton is gay. He and Woodnick touch each other in the most exciting ways.
I can tell why I shouldn't. No, don't do it, David. We can't take it twice. It was bad enough the first time. That's a joke.
He didn't even get the melody right. I mean, it was partly
sort of, but whatever.
Yeah. I dare do any more? I don't know where this goes.
Play more.
People, and it didn't matter. It wouldn't matter anyway. Clayton, you do you, girl.
Right to the misogyny. Let's bash on women too, right? You do you, girl.
Yeah.
Even though we're talking about a guy who's now we're gonna claim he's gay after all this crap with Laura Owens and allegedly being impregnated, fraudulently claiming pregnancy. Come on, he's spiraling. He is spiraling quickly, in my not so humble opinion.
Wow, play more.
Oh God, I don't know that I want to.
I'm born and raised in San Francisco. You don't get a more LGBTQ friendly person than me.
Oh, fuck off! Fuck you!
What a
fuck
dick!
Off!
What a dick! And I know people in San Francisco. What a dick!
I would.
Oh
not
my God, I'm
also-
not racist. I know black people. Oh, shut the
I have gay
fuck up.
friends.
Oh my God. Oh.
I have gay friends. I'm not homophobic.
Right, but I'm going to mock this person for doing all the things that they're so gay.
Jen the Couch Fry asks, "Is this recent?" Yes, Jen. This is from today. This is from the free speech blogs of Douche Canoe Esquire today. You can find it on his real page. For reasons I don't understand, the archive doesn't capture the videos that are on pages, so you have to go back to the real thing to get the videos he embeds. This apparently, according to him and according to the bar here, he has started a Rumble page. So I'm not recommending you follow him on Rumble, but I can't stop you. Just as I can't recommend that you go to his law office page, but I can't stop you. If you do go there, I would suggest using protection as much as you can for your internet.
Use Tor browser, torproject.org. Use it.
Sure. This podcast not sponsored by Tor browser, but
it's not, but it's recommended by Jeep Daddy Esquire.
Okay, very good.
Gay out of to harass them or whatever, but I'm getting a strong gaydar vibe off this kind of thing.
You have no license to use gaydar. You have no license. Shut up.
Douche Canoe with the Trump Pence sign and an American flag in his background today is claiming he's got gaydar. He's appropriating gay culture and gay awareness. Come on.
Yeah, this is like how to say you're not homophobic without saying you're homophobic.
Oh my Lord in heaven! But I was born and raised in San Francisco. I'm not a homophobe.
No, of course not.
No. I don't know what I want to do anymore.
To my earlier comments, yes, I would absolutely climb the Clayton tree. Okay, I would. But if it didn't matter if he's taller or shorter than me. I don't care. That's very distracting on the screen.
Isn't he though? My God,
if he's not.
I'm glad it's like from the clavicle. It's like,
but if he's not gay, I'm not going to do it. In reality,
it's disappointing. It's like, well, we can't have them all, I suppose. I'm afraid.
Yeah, I'm going to say the N word, but I'm not racist. So yeah, okay, right, yeah.
Come back here. I hate it when chat comes with Bruce the Moose says DSG got his gaydar from Temu.
Yeah, basically. Do you want to play some more? Play some more.
I'll stop it.
I don't know Clayton at all, and I don't really care about the guy. But I'm joking. I don't have any information about him and Clayton touching each other. I just did that as a joke to my friend.
Yeah, right.
Just a joke.
Which friend? Which friend? Randazza or this new guy who's so in a lot of trouble? Vlad the Impaler. I mean, toxic Vlad. Vlad Gajic, who still hasn't been reinstated after his little slap fight with the bar and Rachel Mitchell and some others, based on what I've read so far. Yikes.
Wow. Okay, so enough about Clayton. I will tell you this, though, that Clayton just failed law school for like the 99th time. But hey.
What?
Wow.
He's killing me.
Oh my God. Oh my God.
I'm choking on it. I'm choking on the bullshit. Someone save me. I'm choking
the bullshit
on bullshit.
The bullshit is thick. It's so thick in the room right now. It's like about as much gaslighting as I had during. So, because Echoes on Wednesday, before I was able to join, I had to do my corporate nicey wanky thing. There was all sorts of gaslight in the room. It was almost suffocating. And this is reminiscent of that. And we've only watched, 45 seconds? Or whatever? Like, oh my God.
A minute.
God damn it. Play some more.
No, I'm the one that keeps making legal predictions that turn out to be wrong, right? He said that.
Well, stop making fucking legal predictions and you stupid fuck.
Laura's going to pay him. No, she's not. A lot of people don't realize this, but when you file bankruptcy, or whether you don't file bankruptcy,
it just all goes away. It just goes away. It's the magic vanishing red button on your desk. Poof, bankruptcy, it's gone. Clayton can't do anything. It's not turning out that way so far.
Oh, What about that dismissal with prejudice? What about that?
What about now Clayton gets to hold a debtor's exam for her specifically, like as they started at the beginning before the bankruptcy?
Oh, noes.
He's
Oh,
going to say a little more.
noes.
I did hear at least that much. Hang on.
Courts cannot make people pay money they don't have. In America,
Yes, they can. It's called garnishing. Girl, get a fucking job. Then we'll
Girl.
garnish her pay and take it out and pay Clayton Eckert. Too many L's and Y's together. There are ways they can get that money. They can also put liens on whatever mommy and daddy still own. It's not going to be a house. They could sell off cars. That could go towards Clayton. They could sell off things they own. That could go to Clayton. I mean, and again, I say that not as somebody who practices, so I could be wrong.
I wonder,
as I understand, you can file liens against people.
Oh, yeah.
There are proceedings they can engage in to get anything they've got out of them. They could, I want to say they could, this is where I need Tiff. Tiff, big Tiff dog, where are you? I need you.
Where are you?
I need the Tiff bat signal.
Where are you?
It'd be the dog signal, big Tiff dog, right? Yeah, so I need the dog signal. I need Tiff. She needs to help me understand this, because I think you could even press liens against people's bank accounts. I think, maybe. Anything they may have in assets could be fair pickings. I think.
Well, okay, so does the first like 200K ish go to, out of all it, like if they liquidate assets and all that, then Clayton gets the first
And horses?
200K out of that?
As I understand it, he was the only creditor pursuing Laura, at least in the bankruptcy, which is why they filed the adversary proceeding, because he was the primary person she owed money to, or he owed. Wait, yeah, I think I said that right the first time. I'm just trying to confuse myself.
I was just curious, like if that's like order of operations, right? If like, okay, well, they sell vacation house, get X number of dollars. Does Clayton get the first 200K, and then everything else goes towards the rest of the bank or whatever? I don't know how that goes.
Caro says something good.
Oh.
Kauki says, if Laura didn't have to pay her judgment for Clayton, it wouldn't be a court of equity. Money or no money, she is legally required to pay.
Right. The bankruptcy doesn't, I have a vague memory of something like the bankruptcy doesn't absolve her of paying the Clayton settlement.
No, because it's not been dissolved. It's not been any kind of dissolution of that judgment. I mean, that was the attempt with the bankruptcy.
Right.
As I played in my little mashup of him saying, ooh, she doesn't have to give him anything, and all she has to do is file bankruptcy, and everything goes away, and Clayton can't do anything about it. I think he's fundamentally wrong as a matter of law, and I say that as someone who knows nothing about the law.
Because good way to discredit yourself in one fell swoop. Good job.
Well, I may as well be self-deprecating, just to be honest. But I talked about this when I talked about Jen Camp and John DeLynn. That woman did the same effing thing. Oh, I'm going to get a judgment against me for being defamatory against John DeLynn. I'm going to divorce my husband, quit claim the deed to him, try and sell the house, and file for bankruptcy while I move to another state. Did it work for her? No, the F it did not. And she had to settle. She settled, I think, just out of court for $1.5 million in defamation. 1 point something million. Maybe it was more like 1 point. After $1 million, who cares? It was 1 point something million. 1.2, 1.5.
I mean, look, I would be okay with 1.5 mil versus 1.
Carol also says, court judgment doesn't go away if you file for bankruptcy. Just like student loans. LOL. I know. God, my student loans are painful. But until I rack up more student loans, I don't have any to pay. But you never know. Wallace says, no self-deprecating statements. Okay.
Yeah.
Well, I'm doing it to cover my legal bases.
Yeah.
Because I get so many people accusing me of, well, you're not a lawyer, a legal scholar. I'm a practicing prosecutor in federal court who's really close to the Laura Owens case. Yeah, prove it. David, come out from behind the closet, David.
Right.
I mean, what's more embarrassing, calling Clayton gay or pretending to be a woman on the internet? Or at least I believe the Marigold Clark profile was David. Maybe it was Laura Owens, but Who else would claim? I don't know. Maybe it was Laura pretending she wants to be a federal prosecutor. Could have been.
So they accuse like
Could have been.
and Gingras and Rapaza or whatever the fuck his name is, were all bitching about all these internet trolls and Reddit people and whatever. I still feel like that falls into that every accusation is a confession territory,
Yeah.
and maybe it just could very well be them.
Could be.
Could
As
be.
Bruce says, the bankruptcy is dismissed in any case. Very true. Teresa S. says if they can
With prejudice
prove,
and for a year.
yes, with prejudice and for a year, she can't refile in any bankruptcy court anywhere. Teresa S. says if they can prove the transfers were to avoid debt, that would be helpful. No, I don't believe the transfers were to avoid debt. The transfers were an attempt to make Laura judgment proof. That's my belief. Just as filing bankruptcy was an attempt to make Laura judgment proof. It was all scheming and dealing, and I question legality of all of it, quite frankly. I suspect that if someone wanted to pursue charges for that scheming and dealing, they probably could. Will they? I don't know. I don't know where else this goes. I'm scared to play anything else.
America, we used to have, I think, I don't even know the history of it, but I think in England, other countries, they had something called debtors' prisons. So if you incurred a debt and you refused to pay it, even if you just didn't have the money because you're broke, they would throw you in jail and basically make you work off your debt. We abolished that, or we never adopted it in America. We don't have debtors' prisons.
I don't think we ever had that in the U.S. that I recall.
Well, not officially, but we do. Like,
I think that's true about the UK. I remember that about history.
Well, yes, but we do have a version of that here. We have our own flavor of that. Of like, if you're behind and you can't pay your debts, then like you keep getting it's like quicksand. You keep getting yourself further and further and further in, and it doesn't officially exist as a thing, but like eventually, like if you're so far underwater and you can't help it, like if you're 5 cents over on your checking account, you're going to get charged a $35 or $40 fee, and it just keeps perpetuating. And it's like, well, I can't pay that, but I get my next check and I got to do all the things, and then you're going further and further and further behind, and then suddenly you're in, way more like $100, $200, $500,000 in debt to the bank because of fees and stuff. Yeah, that's it. We have that. It's just not called that exactly.
Huh.
Yeah.
Interesting.
It's just backhand. It's just backhanded, but it's very, very, very real here.
Teresa S. also says creditors can get the transfers reversed. Didn't they do that after the trial? Even close to it, it's still fraud. Yeah, I can't remember if anything was transferred after. As you might remember, it seems to me that Laura had sort of divested herself of ownership interest of LLCs to her mother. That comes up in the bankruptcy. Yes. Well, there were people watching it. Tiff talks about it on her channel. So Tiff was watching it and reports on that. But it seems to be both Quartet Farms and Liz Max, the housing investment things. Both of those got quickly shifted to her mother right after the paternity trial, as memory serves. I could be wrong on that, but that's what I remember. So from my vantage point, there was some shuffling about to try and distance Laura from an inevitable judgment against her.
Yeah, maybe.
Or after the trial, which, well, the same thing, really. It's the same problem. Oh, they can't know I own anything, and I have no money, and I have no job, so they can't charge me with anything that I owe Clayton. Ding. 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 I'm just innocent Laura Owens. I don't even know what the difference between an owner and a manager is. Ding.
You keep torturing yourself with this video. I'm going to be right back.
Oh, do I have to? Oh, I'll sniff out a little more. It goes for 30 minutes.
Prisons in America, if you are ordered to pay $1 billion to somebody in damages, and if you don't have the money, you're never going to have to pay it. They don't put you in jail. There's no
If you don't have the money, you never have to pay things. It's a get out of jail free card. I don't think I believe him.
Consequence for being broke. So Laura's not going to be paying Clayton anything as a result of her bankruptcy being dismissed.
Oh, there you have it. Laura's not going to play. I keep saying that. Why can't I say it? It's something about preloading the word Clayton in my head with the word pay before it. And somehow I just can't get that right. That's a problem. Is that a speech impediment at that case? I don't know. Don't worry, Jen. I'm not going to play this whole thing. I don't think I can stand it after all the other stuff we've just read. And, I don't want to tempt him. I don't want to tempt him coming after me. I just don't. He probably will either way, but never mind.
She doesn't have the money to pay him.
Because I think he would like to get my deets and try and dox me and do other things. I don't want to give him the satisfaction. So I would edit some things up before I do that.
He's welcome to go chasing after that. He tried to already. I think what people don't realize is the court doesn't enforce its own judgments, right?
I'm done. I need to put that one on. I'm gonna have to borrow some of this. I'm gonna have to borrow this and put that on loop. The court doesn't enforce their judgments. The court doesn't enforce the judgment. Oh God. What do I do? What do I do with this stuff? Oh, I'm going back to chat. I don't think I can handle anymore. There might be some more zingers in there, but I don't know if I might have to suss them out first. Oh, let's see. Jen the Couch Fairy says, no, let's back up. Bruce says, why is DSG talking about how there's no debtor's prison? Nobody said Laura was going to debtor's prison. This is a red herring. Well, she might end up going to real prison. There's still a small chance there, I think. No one has accepted any plea deals, so that's still on the table. Okay, Jen says maybe we should have required work to pay judgments like restitution in criminal court or community service hours. Interesting idea. Jen also says Laura won't ever get a real job if she isn't forced. You might be right on that.
Probably.
Teresa says it's scary to think her going to work, though, for coworkers and supervisors. Fair point, Teresa. Fair point. Oh, no. Okay, everyone needs to have a 40-foot rule with Laura Owens and wear your body cam. We don't want any unwanted twin pregnancies here. Oh, this is getting outrageous. Minnie T says the court will see that for what that is and unstuffed. Okay. Unshuffle. Fine. Wallace says, or actual parents skipping out on child support payments when they're real babies. Yeah. Let's see. PCB Amy says, when Laura gets out of prison and doesn't have her parents one day, I guess she's going to be homeless because she'll never want to earn money because of paying Clayton back. Who knows? I would like to think, and I know Dave Neal is the eternal optimist because that's just Dave. Dave is very optimistic. He believes all humans can find healing and renewal. And he has good hopes for Laura Owens that she will, at some point, the light will go on and she will realize the errors of her ways and correct herself. Which is very optimistic. Dave is entitled to believe that. However, my life experience has suggested there are just damaged people who are dysfunctional and will always be so.
Yeah,
regardless
will...
of psychopharmacology and therapy, there are just some people who are too far gone to be redeemable.
And my life experience would also echo that. No pun intended to your name, sir. But Jeep Daddy joke. But yeah, like I would have thought at some point that even like some of my family members, my bio dad in particular, would have actually like done the same. And like, oh, I'm getting older, things matter differently, blah, blah, blah. No, he didn't. They don't. With that level of psychosis that they have, they don't ever, like, that's just not, it's not part of their programming. They can't do that.
some neurological structures are just beyond repair.
That's just how that's just how they're wired.
Yeah. And it's not easy to change wiring yet.
Not yet.
Yet.
But
Yeah.
if I can find a way to change my neural wiring for the better, I would be grateful, because I have a lot of acronyms that I've been diagnosed with that I'd rather not have to deal with in this life. But
IB says it well. It's hard to change after 36 years of dysfunction. Not without a lot of aggressive psychological, psychiatric, therapeutic, and a few other medical interventions, I would say. Lots of behavioral analysis, all kinds of stuff.
you have to be willing to help yourself, and you have to be willing and desire to want to change your perspective and how you manage your challenges. Because again, you can't change the way that your brain is configured, but you can change the way that, like, if you have more awareness about how things are and how you perceive the world, and if you have any ounce of like empathy towards others, you can adjust the way that you interact with the world. Some people, again, like my bio dad, were just unwilling to do that. Just he didn't care to.
Good night to Minnie T. Pleasant sleeps.
So, and it's fine, because at this point he's not here, and I don't have to deal with that anymore. And there's a couple things that I have in my life now that I honor as a honorarium to him, but also at the same time, like, knowing full well that if he actually had put together like a will and all that fun stuff, I would have been completely cut out. But he didn't, and so fuck you. I now have your truck and your trailer. So
Yeah, you've got another diesel hog in your life.
that is true, and but I love my diesel hog. You haven't ridden in this one yet, have you?
Yeah, boys and their toys.
It's true. But my point is that he could have, if it was possible for him to change that and want to have a relationship with me, he could have. But he dug into his arrogance and dug into his narcissism and chose not to. I'm just grateful that he had health problems to the point that, like, he had the paperwork to file his will and all of that, and he was so weak in the mind and then ended up expiring unceremoniously prior to him being able to do that I didn't get completely and utterly fucked. But yeah, that is what it is.
IB says empathy is key. If no empathy, there's not a lot of motivation to change. Yeah.
Yeah.
Some of it has to be self-perpetuated. It's got to come from within. I mean, just like with addiction, you will never get over addiction if it's not from within. You can't be forced to do it. You'll relapse. I mean, all those things. There are similar mental structures that are in play there. Some people would say it's not an apt comparison, but psychologically, behaviorally, they tend to be a lot more similar than they are dissimilar. So it's all about rewiring the brain, but that's not an easy thing to do after certain neurological pathways have been established.
It's just that sometimes that's just like how you have to manage things going forward and have the right support structures, whether it's pharmaceutical based or whether it is therapy or friends and family of choice, much like the relationship that Echoes and I have, to be able to like deal with fucking life. Can we get this asshat off the fucking screen? Are we done with him?
I don't think I want to do any more without knowing where it's going. If you know what I mean.
I'm going to push the button.
Very
then.
Good.
I feel like, as I've gotten to know this saga of the Laura Owens scenario here. Like there's so much lack of empathy, and there's just narcissism and self-driven, selfish motives. Like this whole like take advantage of men, take advantage like the mom situation, like Laura learning from her. All of that. It's just like Christ Almighty. Like no wonder, no wonder that Laura's doing all of this shit and making shit up and trying to go after Clayton for hundreds of thousands of dollars because she couldn't do it on her own merits. She literally couldn't just go out and do that. She had to try and manipulate others and fuck people over. Like, yeah, it's just unbelievable.
Amy asks,
I don't know, whatever.
Amy asks, have you two been listening to the podcast? I have. I have not missed a single episode nor bonus content. I race in the morning to catch it every Thursday. I can't help myself. I'm disappointed that we aren't getting hours of bonus content every single day. But that's the way it goes. I would suck that stuff up like a Hoover. Good stuff. We sniffed a little bit out last time. We had a little bit.
A little bit. Yeah.
Just like we had a little bit of douche canoe. Just a little bit. Just a taste. Just an aperitif appetizer.
Just the tip.
Just the tip.
Just the tip. Yeah.
Oh my goodness. Oh, I think we need to stop this thing. I think we've rolled over the 3-hour mark yet again.
We have, and our East Coast friends are still hanging in with us. Like Ivy in particular.
Why.
Like I don't know why. What did
Insomnia?
the fuck? Why? Really?
Insomnia.
Like.
Well, see, then I'll have to develop, sort of a half-hour closing. And now the soothing part of this program that lets you relax and decompress and lull yourself to sleep after the insanity of David Gingras and Laura Owens. Breathe with me in a count of 8. I mean, I need to be playing soothing music and
drink for the count of 8, and then swallow for the count of 8. Just don't get throat babies at the count of 8.
Oh,
you'll be fine.
Toadette says, "Shh, don't say Hoover. It triggers my dog." Is your dog named Hoover? That would be unique. Oh, you get to read this one. You get to read that one.
Just a tip.
Thank you, Wallace, for the Canadian 5.
Yes, just Canadian 5. Yeah, just the tip. I think next time what I'm going to do is I'm going to go up and get some of my Canadian currency that I have, and just like when these CA pesos come through, I'm just going to like play with them on the camera and like we'll make a prop out. Yeah, just clink them. It's fine. I have loonies and toonies and quarters and all the things. Like I'm not that ignorant of the currency up to my friends in the north.
Somewhere I've got lots of euros, but yeah. What do I do with that? In another episode, we'll have to listen to some of the 911 calls from Laura Owens. That's really hot right now. I haven't really hit on those. I've done the body cam stuff, but I haven't hit on the 911 calls so much. Some of them are pretty damn funny.
Ooh, that sounds kind of spicy and interesting.
Yeah, some of them are pretty funny. So in our lulls between bar things, maybe the bar stuff's not going to be done till summer, supposedly. So we'll have some time to fill. We'll have to do some backtracking in the antics of one Laura Owens, currently indicted on 14 felony counts. Just for additional flavor and context.
No, this is just for your entertainment purposes of torturing me live on camera. To the people who like my rants, and you're provoking me into more rants.
Well, give the people what they want.
I mean, it was kind of fun ranting and venting earlier. Just saying,
Yeah, ranting and vanting. That's not a word, I don't think.
We'll just mesh them together and call it vanting.
Ranting and venting.
Hey, and I've
Vanting.
even ranted a little bit on my own channel, right? Like
Sure.
I did enter a couple of those and have a couple of snarky comments on some upcoming videos I need to edit from some recent stuff where there's just trash fucking everywhere. And there's just troglodytes with their fucking guns and bullshit just out shooting. They're not supposed to be doing it. And there's like shells everywhere. And it's like,
Oh dear. How rude.
God.
And they leave their garbage around, I'm sure.
There's cans and garbage strewn across. I need to go back and like take a picture of this like big framed thing that was like a shelf. I couldn't quite tell what it was, and when I was coming back down on that trail, I saw it and I stopped and I was trying to figure out what the fuck it actually was. And I should have just taken a bunch of photos because like I don't get it. I don't understand why that ended up where it was, nor what it was to begin with. And part of me wants to take my big fucking truck that I got from said father and a trailer that's just big and obnoxious and just go winch all this shit out. Like, fuck it. Let's just go make a project out of it. But whatever.
That sounds like too much work to me.
You're coming with.
Not unless I get to drive the bulldozer.
There's no bulldozer involved. You're just going to sit and be passenger
there
princess.
should be.
Be passenger princess and make snarky comments. Or occasionally get your ass out of that truck and pick up a
Can I
piece
fly
of
the
garbage off the
drone?
side of the.
How about I fly the drone?
Yeah, maybe.
Let's do that.
Not on your. You can't be on your channel because you're monetized, so that requires a different license. But on my channel, you can absolutely do that.
What? You have to have a license for your drone?
Yes.
Bastards! It's your property. Why do you need a license?
Because the government, because FAA. So my drone is of a certain size that requires a license to fly, and I can fly it under recreational purposes only. But I can't do it if my channel is monetized, or I can't produce videos legally, technically speaking. I can't go and fly for like real estate agents or YouTube people or anything if they're monetized and making money because it's a commercial venture. So I have to get a different type of license and operate my drone under a different rule. A Part 107 is what they call it, I believe. And that requires a different thing. But I can just go, and if I wanted to take pictures of a golf course or like pretty sunsets or something, and just like on my random channel that does zero fucks about whatever, it's like, yeah, okay, I could do that. It's fine, no problem, as long as I'm not making money.
Oh dear. Okay, I guess it's just more work than it's worth. Because it sounds like fun flying a drone around.
It is. I can tell you that.
Yikes. Oh, well, we'll have to work on that little problem.
I'll figure out how to incorporate drone things.
Well, if you're not monetized, it doesn't matter. So
yeah, on my channel right now, I don't give a fuck. But if
all you have to worry about is the FAA part of it, then that's one thing. But
yeah, but they don't have a sense of humor, so
no, of course not. Nor should they. I mean,
much like Bruce mentioned earlier in the chat, they have a very rigid stick up their butt.
The FAA?
Yes.
Yeah, I don't blame them. With all the craziness that happens with airplanes, can you blame them? No.
But
although there was a funny guy who was an air traffic controller at Kennedy, and he had quite a following. I followed him till he retired, and people were taking audio of him while he was at work because he had the most amazing sense of humor, moving traffic at Kennedy, and the guy was hysterical, and he had the nickname Kennedy Steve. Is that right? Yes, I think so. I think Kennedy Steve was his name. Yeah, funny ATC guy, retired at his almost 60s because there's a mandatory age you get retired out for being air traffic control because it's high stress and high all those things. You get aged out. So, yeah, Kennedy Steve. I'm pretty sure that's the name. Yeah, but funny. He would crack all kinds of jokes and never at the expense of anybody. Nothing was unprofessional, but he just had a great sense of humor, especially when there are traffic jams on the multiple tarmacs at Kennedy Airfield. Yeah. Kennedy Airport's one of the busiest in the country.
It is. And
They don't
a
play
giant
around, but the
clusterfuck,
guy
too.
made it enjoyable. Very entertaining air
least
traffic
that.
controller. Yeah. Oh golly. Okay, I think we can stop this thing now, right? Have we had enough? We've had enough.
Maybe. Did
I'm
you have
not
something
even.
to play us out, or are you just like done?
I think I'm done. I started us with the bankruptcy thing, so I think I'm done.
You did. I missed
That was
most
enough.
of that, but
I know. That was enough, and your clock is dinging. So it's so long.
well, it's
farewell, auf
it's
Wiedersehen, adieu, adieu,
but as
adieu,
Chat has pointed out, it is fast. It is fast.
I'm going to get through the whole song before he figures it out. Jen the Couch Phrase says, yes, Kennedy Steve still has stuff here on the tubes. Yeah, it's good stuff. There's a bunch of stuff archived now. He was hysterical. And he got some awards when he retired, so it was good stuff. Now he's happily living in retirement. I actually saw interviews with the guy and some other people that talked about his career and his fame as it made its way onto the internet that he didn't know for many years. He was on the internet for all his conversations. Good stuff. Good stuff. If you like airplane things.
Oh, yeah.
Alrighty, I'm going to call
airplane
it.
and airport and airplane porn are a thing, and no shame.
Yeah,
That's
very entertaining.
Yes,
especially when they're funny people.
Yes.
All right, so do your final goodbyes and Jeep Daddy rants.
Oh, I mean, fuck Gingras, fuck this whoever, like, fuck, like, whatever. Just, Gingras, go put something up your butt and feel something good for once, all right?
God.
Just go, just kiss my ass, all right? Fuck you.
Don't
fuck you all the
Stop it.
Well,
Stop it.
Yeah, well, whatever. I don't give a fuck.
I do. Stop it.
I know you do. I just okay.
Don't get me demonetized, damn it.
Look, at hour like 3.5, you're probably going to be fine. But anyway, that's my final like little mini rant. Thank you all so much for joining. Please make sure to remember
hit the buttons, the likes and subscribes.
If you haven't done that.
We like the
we
hype.
Have hype. We have hype. Oh my God. So do that. Help out my dear friend Echoes here to grow his channel a little bit more. And I appreciate all of you hanging on, particularly the East Coast folks that it's like
and
way
further.
past your bedtime. It's great. And I'm going to go ahead and excuse myself, and you can go ahead and close us out.
I have nothing more to say other than thanks, everybody, and bye.